The Senate Judiciary Committee will come to order. The first item of business will be to introduce the staff. We have an outstanding staff. Charles, would you like to introduce the staff, and then we can give the deputy clerk as well.
Sure, Mr. Chairman. This year we have back as Steve Benjamin as counsel to the Judiciary Committee. We also have a new DLS staff person, Sabrina Miller-Bryson, joining us. She'll be handling the civil bills. And I'm Charles Quagliato, and I handle the criminal side. And we have a new clerk this year, MJ. If MJ would like to introduce himself.
My name is Michael Jackson, MJ. I'm with the clerk's office, the committee clerk for this committee. And over here we have our interns for the year, who is Claire Dunn and Andrew Horton. Andrew Horton, thank you.
Okay, and Shannon, like to introduce yourself?
I'm Shannon Hurd. I'm Judicial Selection Administrator for Courts and Judiciary.
Okay. I was going to introduce the entire members of the committee, but not everybody's here. But when they get here, we'll introduce them. Meanwhile, I'd like to go forward with the presentation to the committee of the the Judicial Inquiry and Review Commission. But first of all, we'd like to call the roll. All in favor, all here, vote aye.
Mr. Chair, you have a quorum.
Okay, thank you very much. Yes, Shannon Huell, the members of the Judicial Inquiry and Review Commission are going to give us a presentation. So welcome.
Thank you.
And you're a judge?
No, Senator, I'm Ray Morrow, counsel to the commission. But
That's
thanks
right.
for the
Okay,
promotion.
yeah, Ray,
I didn't deserve it, and I won't get it.
Didn't recognize you there. Thank
Anyway, good morning, everybody. Thanks to all the members of the Judiciary Committee, and especially to the co-chairs, Senators Deeds and Edwards. It's a pleasure to be here this morning. I have a presentation. My hope is to give you some background about to some folks who may not be as familiar with this organization as others who practice law and so forth, about the origins, composition of the committee, commission, and how it operates. I'm sure there are going to be some questions. I know there's some pending litigation and other issues that may come up. So obviously, I know you'll feel free to interrupt me at any time for questions. I will say I'm here with my co-counsel, Benjamin Katz. He investigates the cases and is one of the most brilliant lawyers I've had the pleasure of working with in my 40 years as a lawyer. As you may know, the Judicial Review Commission was created as a result of the adoption of the Constitution in 1971. Article 6, Section 10 provided for the formation of the Judicial Inquiry and Review Commission. And that provision made clear that the JIRC Commission should consist of members of the judiciary, the general public, and the bar. Further legislation enacted by the General Assembly, as well as provisions of the Constitution itself, provide that the legal or the lawyer members of the commission shall have at least 15 years of practice and must be active practitioners of the law at the time they're on the commission. The commission consists of 7 members, 3 judges, a circuit court judge, juvenile court judge, and a general district court judge. I will say, if I may, that these are very distinguished judges with good reputations, and they are appointed by you all, I think, for that reason. We have 2 civilian members currently. One is the head of the NAACP and a very distinguished community servant in the Northern Virginia area, Prince William County. That's Reverend Cozy Bailey. We also have Ms. Terry Thompson, who is a citizen member. Some of you may know her. She's been very active in the community down in more of the southern regions of the Commonwealth of Virginia. She is an expert in human relations law, not law, but human relations practice, and serves, I would say, with distinction on the commission. The 2 lawyers, one is Catherine Dickerson from Northern Virginia. She is a private civil practitioner up in Northern Virginia. And the second is Trip Franklin, otherwise known as Humes Franklin. He is a lawyer who engages in medical malpractice and an assortment of civil type cases. I will say that having been a prosecutor and a defense attorney for a long time before I was fortunate to be given this job in my retirement, but I will say that, having tried a lot of jury trials, that if I was a defendant or if I was an accused or if I was a complainant, I would want these 7 people. I can tell you that I've been nothing but impressed with their diligence, their fairness, their sense of equity. I don't always agree with everything they do, nor do they probably agree with everything I do, but for those of you who go to court and try cases, people don't always agree, but I do think they mostly get it right, and whatever they do is for the right reasons. The complaints are handled in the following manner. We get written complaints from the public. Signs are posted, as you know, outside each courtroom telling people they can file complaints and how to do it. The process is also set forth on the Supreme Court's website, and Benjamin and I man the phones every day. We get a lot of calls from citizens talking about their cases and, their complaints about the judge's rulings and so forth. I will tell you that the number of complaints that we get are logged, and records are made of every one of them. And the number varies by year slightly, but the number generally falls somewhere between 400 and 500 complaints a year. There were 415 in 2022, 395 in 2021, 392 in 2020, and so on and so forth. The complaints have always been overwhelmingly made by citizens who are complaining about the rulings and decisions of a particular judge. That is by far the vast majority of cases that we get that fall into that category. Complaints that addressing dissatisfaction with the judge's legal decisions fall beyond the authority of the commission to review. It has no authority to reduce or reverse the decision of a judge, and so we advise those folks by letter or by phone, if they're calling, that their best bet is to speak to a lawyer and file an appeal of that decision. Individuals who have submitted written complaints on that basis, again, are notified, and we document all of those cases under Rule 3A3 of the rules of the commission. We respond to those individuals, and then we present that list of matters to the commission every month at their hearing. We give them a list of however many we got that month, 25, 30, with the names, the complaint, and the commission is invited to ask us, why is this not a valid complaint? And typically the explanation is the person was dissatisfied with the judge's ruling, but there are other reasons as well. During the, once a complaint is taken on, the commission decides it has sufficient information to proceed. During this initial phase of the commission's review, the commission may choose to take any of the following steps. 1, the members may determine that the investigation has failed to demonstrate a basis for the commission action and dismiss the matter as a result. The members may decide that the facts are sufficient to warrant communicating to the judge the disapproval of the membership, suggesting areas for the judge's improvement without taking further action against the judge, or the members may choose to communicate a desire to hear a response to the accusation from the judge in writing, or it may seek to hear from the judge in person. These options afford the commission a degree of flexibility in response to each case. And any action they take may be tailored to reflect the circumstances of a particular allegation. If at the conclusion of the initial review stage, the commission members find that the complaint before them is well-founded, they may elect to gather additional evidence. The commission may convene an investigatory hearing, taking testimony from live witnesses or depositions to determine whether the facts support the retirement, censure, or removal of a judge. Alternatively, or in conjunction with an investigative hearing, the commission may invite the judge to appear for an informal conference. Finally, if the Commission's members are prepared to consider filing a complaint in the Supreme Court of Virginia, they may choose to proceed to a formal hearing. A formal hearing serves to afford the subject judge the due process to which he or she is entitled, permitting the judge the representation of counsel, the opportunity to call for witnesses to testify in his or her behalf, and the opportunity to cross-examine witnesses as they see fit. In addition, Virginia Code 17.1911 affords the Commission the opportunity to suspend a judge if the Commission finds probable cause to believe that the continued performance of judicial duties by the judge constitutes both a substantial and immediate threat to the public interest in the administration of justice. Where the Commission determines sufficient evidence exists to meet this standard, the Commission staff prepares an order of suspension. We send it to the judge, and the judge has 15 days or is entitled to a hearing within 15 days to contest the suspension and challenge whether or not the suspension is necessary to protect the public at that point. Once judges are suspended, they are not allowed to appear in the courtroom. We notify them. We have a sheriff serve them. They're not allowed to appear even in the courthouse. So it's a pretty severe kind of a thing for a judge to experience. The canons of judicial conduct, and if you read the preamble, they readily acknowledge that not every transgression of the canon should result in a disciplinary hearing. That's a quote from the preamble. Where the evidence is, quote, well-founded and of sufficient gravity to constitute the basis for retirement, censure, or removal, the Commission may consider filing a complaint in the Supreme Court of Virginia. However, for matters that fail to meet the threshold of sufficient gravity, the tools outlined above, or that I've spoken about above, the hearings, the opportunities to receive letters from the Commission to do better and such, provide the Commission's members with a means by which a judge may be placed under supervision, permitting the members of the Commission to monitor his or her progress. And I have observed that this does occur where judges either are late in getting their orders or are engaging in some type of behavior. Mentor judges can be appointed to help the judges improve, and the Commission does monitor them through Benjamin and I, and we check with clerks and lawyers and follow up with them to see that if they respond to that that situation, that or lenity, I guess, that is given to them by the Commission. Just briefly, confidentiality. I know this is something that members of the General Assembly and the Senate are concerned with, and there may be some changes. I just want to say, we're here to give you any information we can. As you know, 913 makes the proceedings of the Commission confidential, so I'm not at liberty to give details of individual cases at this point. But if there's anything Benjamin and I can do, and the Commission has made this clear, we're to do it to get you whatever information you need to make decisions as to what is appropriate. With respect to confidentiality, as the members know, that 1971 Constitution authorized the General Assembly to pass legislation making proceedings and documents before the Commission confidential. The General Assembly did so in Code 17.1913, which observes that all papers filed with and proceedings before the Commission shall be confidential and shall not be divulged, except that the record of any proceeding filed with the Supreme Court shall lose its confidential character. This mode of procedure provides a host of benefits to the public, to the judge under consideration by the Commission's members, and to the judiciary as a whole, rendering a great advancement over the former process of impeachment. The confidentiality, which was the only remedy before 1971 and the subsequent legislation following it, the confidentiality afforded to complaints made to the Commission permits the public attorneys and judges who may wish to make a complaint to do so without fear of retribution. Sometimes the person who makes the complaint really isn't concerned with secrecy, but a lot of times the complaints involve other lawyers or court clerks or people who work in the courts, and they, as you can imagine, are very reluctant to have their names in a situation involving a judge that perhaps they respect or fear, or they work in that building with that judge. Same thing is true of some citizens who have recurring business in the courthouse. If a person has one case, they might not care about the secrecy. They might want it to be public, but some people run businesses where they lease properties or they have recurring civil cases in a court, and they can be very concerned about, I guess, fear of retribution and just the collateral effects of this becoming public. So in the opinion of at least some on the commission, the juror commission, this confidentiality facilitates the cooperation of witnesses without whom the commission's members would be unable to develop sufficient evidence to determine what outcome, if any, may be appropriate response to a complaint under investigation. Confidentiality also protects the reputation of a judge who may be innocent of the allegations made against him or her, providing the commission with an opportunity to develop the necessary factual record to reach a determination as to whether a public proceeding may be appropriate. In turn, this process prevents the diminution of the public's perception of the entire judiciary's integrity, as might be the case if a deluge of meritless complaints were brought to the public's attention. Such circumstances would present a risk that the public may see only the total number of complaints made without possessing the requisite understanding that the vast multitude lack merit, leaving only the impression of a lawless judiciary. If I may speak briefly about public proceedings in the Supreme Court of Virginia. The Commission's most recently filed complaints in the Supreme Court of Virginia, in 2017. That court issued an opinion in one matter of July in that year, and an order was entered resolving a second matter in November of 2017. I would submit, however, that reference to the number of complaints filed by the Commission's members in the Supreme Court represents an inaccurate measure of the Commission's level of activity. It is a rare case that demonstrates sufficient gravity to constitute the basis of a public filing in the Supreme Court of Virginia seeking a judge's retirement, censure, or removal. And in Virginia, that is the remedy in the Supreme Court, retirement, censure, or removal. Other states have public sanctions, private sanctions, even fines. And I will say my research indicates that in most states, 1 or 2 judges are removed per year in a formal proceeding. It's a rare case, as I said, that demonstrates sufficient gravity to constitute the basis of a public filing in the Supreme Court of Virginia seeking retirement, censure, or removal. Since 1971, the creation of the Commission, only 14 matters have been brought to the Supreme Court of Virginia. Moreover, from the time of the Supreme Court's removal of Judge Harold Maurice in September of 1977, no judge was removed as a result of the matters brought by the Commission members to the Supreme Court until 2007 in the inquiry concerning Judge James Michael Shull. During this 30-year period of time, a total of 7 matters were filed in the Supreme Court's original jurisdiction. As I've mentioned earlier, the Commission possesses a variety of means by which it is able to address concerns regarding a judge's ethical conduct. In some serious matters, the Commission's members are called upon to consider a judge's request for retirement or resignation in lieu of further Commission action. In such cases, the unique circumstances of each matter are taken into account by the Commission's membership as they reach their ultimate determination. In doing so, one factor given great consideration is the nature of the issue concerning the judge. Here, a distinction may be made between claims of ethical misconduct, moral wrongs, things that would shock a person, and things that are more medical in nature, or perhaps mental health type issues, or could even be a substance abuse issue. And I myself have seen several cases with respect to judges just in declining years struggling with the issues that go with that. However, a judge removed from the Supreme Court as a result of disability that interferes with the judge's performance of his duties. Oh, I want to say this. In the Supreme Court, if we bring a formal case to the Supreme Court and it's a misconduct case, it's some ethical misconduct, it's punitive. The Supreme Court, should they remove the judge from the bench, it's punitive. In other words, they forfeit their retirement. But if it's medical, if it's a mental illness kind of a thing or something like that, the judge may be removed from the bench, but the judge's retirement is not forfeited in that case. So we believe that's a recognition that the Commission is correct in discerning in each case, what is the exact nature of this violation? Is it, moral, ethical misconduct, or is it just somebody who has some depression, could be, or other mental health issues? And I know this is of some controversy lately, apparently, but I will say that when the members consider a judge's request for retirement or resignation instead of a formal commission action, they weigh the length of any expected litigation, the likelihood of that litigation success, the risk of establishing negative precedent as a result, the expense of any expert testimony that may be required, and the expected cost to the Commonwealth in providing counsel to the judge for this purpose, as well as the ongoing cost of the judge's salary, which would be paid regardless of whether the judge were suspended by the commission in the interim until the conclusion of the proceedings. So it's like for those litigators here, when you have a personal injury case or a criminal case, you weigh, it's a cost-benefit analysis. What is the benefit to going one way as opposed to another? What is the cost? And of course, judges are entitled to be appointed lawyers who are paid for either, through the Commonwealth of Virginia. Typically, they get private counsel. They go to the Attorney General's office, they're assigned private counsel. In cases, I can say this, I guess, without breaching the confidence, Benjamin, stop me, but if there is a ethical violation by a judge that implicates some moral transgression or some misconduct that is really, nefarious in nature, and the judge is allowed to retire, they do retire immediately. The cases I've seen, I'd say it's been 2 a year since I've been there. I've been there 2 years, which sort of coincides with, it's usually a couple of cases in each state where someone's formally removed. Here, I have seen cases where the commission says, we're going to a formal hearing, what are you going to do? And the person, I want to resign now. In one case, I know that well, I can't say what they did in a case, but I know that they can say, and you don't get any retirement. You have to write in and say you're not getting retirement, and I know that has happened.
Mr. Chair.
Yes.
Senator
I
Peterson.
apologize, sort of break into the colloquy, but I have a bill this year actually on retired judges and retired judges that left under less than ideal circumstances and then are allowed to come back as a judge. Is that something, do you all have jurisdiction over retired judges?
Yes, if they're subject to recall.
Okay, so if they are recalled to the bench, let's say.
If they're even subject, Senator, we have jurisdiction.
Okay, so my question, if I can be more precise, if there's a complaint made against a judge and the judge says, I'm retiring, so there's no public hearing, and then they retire, and then they get right back reappointed as a retired judge, where do we stand there?
Yeah, well, that would depend on the facts. I will say that if a judge, the complaint is made and the commission is aware of it and they're moving forward, we've investigated, we've got witnesses, and the commission, believes this is a valid case. If that judge can't just retire and then go on the recall list. The commission wouldn't let them do that.
Okay.
If they had notice of it, because that's always in the agreement is you're not to be in a recall. You're not, and even I will tell you, the commission typically, I don't make the decisions obviously for the commission, but the commission in my experience will also say you can't even mediate. You can't have anything to do with any legal processes.
It's like a dishonorable discharge. Okay.
It's
All
a
right.
great analysis.
Mr. Chairman.
Yeah,
Yes, sir.
Senator
Serville.
Norman, I think, has a
Okay.
question.
Thank you, Mr. Chairman. I have a two-part question, sir, and I appreciate your presentation because it's very informative and I think helps many of us. A word that has been bandied around in the General Assembly for the last couple of years that sometimes sends shivers down my back is transparency. And it's on. Okay. My question to you is two-part. One, if a citizen complaint against a judge is made and the commission acts on it regardless of what the disposition is, what is that citizen informed of? And the second part of it is if a member of the bar files a complaint against a judge and the commission acts on it, what is that attorney advised as far as the disposition?
I believe I'm correct, Benjamin, correct me if I'm wrong, but that citizen gets very little information. They get a letter, if it's being investigated, the letter will say something to the effect of, we have your complaint, it's submitted to the commission, we'll inform you when the matter is concluded. And then when the matter is concluded, no matter what the conclusion is, it could be counseling for the judge, it could be a program for the judge, it could be anything short of a formal type proceeding. The person gets a letter that does not inform them, I think is what you're getting at, does not inform them as to what happened. It'll say, your case was presented to the commission, they took the appropriate action. And I think the same is true with lawyers. Although lawyers tend to have more details of the events in our,
Mr. Chairman, just a point of clarification.
Senator Norman?
Thank you, sir. So regardless of who has filed the complaint, once a decision is made, the correspondence says appropriate action was taken, but it doesn't even infer what that appropriate action is. Is that correct?
that's entirely correct. Yes, sir.
Okay,
Mr.
Senator
Chairman.
Morsi? I think Senator Morsi had a question.
Good morning, Mr. Muller. Thank you
Yes,
for your
sir.
presentation.
Thank you, sir.
A few questions to follow up on Senator Peterson. You indicated that since 1971, there have only been 14 referrals to the Virginia Supreme Court. Isn't that more a reflection that there are not ethical lapses, but rather the judge decides to retire so as not to go before the Supreme Court where there's an open hearing?
I'd like to think it's because we have an excellent judiciary. I have to say, like in a lot of states, judges are elected, and I read the cases from other states, and it's really shocking the kinds of things you see.
Okay.
I think that, I think the process of appointing judges by distinguished, members of the House and Senate, it works really well, and it's kind of the hallmark of Virginia's system is that we have great lawyers. But I get your point.
Follow-up, thank you. Follow-up question, Mr. Chair.
Yeah, Senator
Are
Morsi.
the full hearings before the Judicial Inquiry Review Commission panel, are they open to the public or are they private? And what is the rationale if they are in fact private?
They are private, Senator. It's just like a trial that you would conduct. I would call
Most trials are open to the public.
That's true, but this is the General Assembly has enacted a statute to say that these are confidential, so we can't open it to the public.
Follow-up question, Mr. Chair.
Yeah, Senator Morsi.
The General Assembly passed laws that requires the Judiciary Committee to provide House Courts of Justice Committee and Senate Judiciary Committee with reasons, full reasons, all information associated with a complaint on a judge that is up for reappointment. The Judiciary Committee has not been doing that, requiring, I appreciate you acknowledging that, requiring former Delegate Mark Levine to file a lawsuit saying, please provide us with the information that the law requires. It's mandatory, shall. Why is JERC not providing the General Assembly, the leaders of judiciary and courts of justice, with the information when we have to reappoint a judge and we're not getting the full information?
Right. So we're referring to 17.1918, the Commission's duty to provide information under that statute.
Yes, sir.
Yeah. Unfortunately, that mandamus that was filed, as you know, it was dismissed, but there was not an opinion explaining the reasons, so as sometimes happens. But I will tell you that the Commission's view is that it is providing all of the information. If it's read the way that I think it was, is it Senator Levine or Delegate Levine?
It was former Delegate Levine.
Urged, with all due respect, Delegate Levine urged it to be read, would require the Commission to give all sorts of information about unfounded cases where judges had no due process, the cases were not found to have any merit. It would really render the confidentiality statute moot. It wouldn't mean anything, because what it would be is an hourglass. It's confidential until the judge is up for reappointment, and then every Tom, Dick, and Harry who's filed a bogus complaint against a judge gets that complaint to go to the General Assembly. The Commission hasn't read it that way. The General Assembly has accepted that interpretation for decades, but I do understand what you want.
Final question, Mr.
Yes,
Chair.
Senator Morsi.
Thank you, Mr. Chair. Many people that have filed complaints would suggest that they are not every Tom, Dick, and Harry, and they're not complaining because a judge gave a sentence within the sentencing range. But almost every complaint that has come to 140 different legislators, the complaint is the manner in which they were treated in court, the judge's demeanor in court, the way they were treated either with courtesy or not. That's what they're interested in, and the public gets no information whatsoever when the juror committee decides either it's not founded or you give a secret, non-disclosable punishment. Do you think that's right, that the members of the General Assembly do not get that information as that was, or the facts and circumstances as to why a judge was disciplined, and then we are charged with reappointing that judge, not having that information? Do you think that's right?
Well, that's an interesting question, but let me make a distinction. I do think it's right that you don't get information from people who file a complaint that say the judge was rude, the judge was this, the judge was that, unless the judge has been afforded some due process, and we do investigate those cases. We ask for transcripts, we talk to the witnesses who were there, and in many cases, many cases, the clerk, opposing attorney, other people say, that never happened. The judge was not rude. If the judge is rude, if the judge does violate the canons by his demeanor, could be facial expressions, other acts of disrespect to the public, and the commission finds probable cause, you will get that.
Right.
That will get there, and I do understand, the transparency, but you have to balance it with what is the benefit of the confidentiality to the system as a whole, and this is for you to decide, not me, obviously.
Yeah, Senator Searle.
Thank you very much. Thank you for your answer. Thank you for your service. Thank you, Mr. Chair.
Thank you, sir.
Thank you, Mr. Chairman. And Ray, it's good to see you over here to this side.
Yeah, sorry.
It's good to see you. And
thank you, sir.
It's also good to see Ben, who has a lot less hair than the last time I had a case with him. At least on, he has a lot more hair on his face. The complaints I get are twofold. One is the confidentiality piece. The other one is, I think, the issue we get from the public is complaints about a judge's decision. So can you sort of articulate for us sort of where the line is as to when a judge is not following the law, so either badly or repeatedly or consistently, as to where that becomes an issue that you all have to deal with as opposed to an appellate court? Because I think that's probably the source of most of your complaints is I didn't like some decision, and you all say that's for an appellate court. But I think there's sometimes when some judges just decide they're not going to follow laws anymore, and they're going to do whatever they want, and it seems to me that kind of moves to a different space. I'm just curious where that line is, because I think that would be helpful to a lot of people to understand.
No, I think that's an excellent observation, and that is a very difficult avenue to deal with because, as I've said, the commission doesn't, second guess the rulings and decisions of judges. But as counsel, and I think the commission itself, needs to be aware that there can be occasions where there are issues of competency, and this has come up. And we have researched and looked into cases where those allegations are made. It's a very difficult thing to deal with because, there's always two sides to the pancake, and somebody is telling you the judge was correct and someone is saying they were not. I've noticed some of the reversals. I followed some of those cases and I've seen the reversals, and I don't know and hope that gives the judge some manner of education, at least informs the General Assembly that perhaps, somebody's not following the law. But those cases could result in a disciplinary process if a judge is flatly ignoring the law. I will say, I've only been there 2 years, and I don't know the whole history of that. Maybe Benjamin could speak to that. But I will say that's very difficult, an excellent point. Did you have anything to add? Yes.
Thank you very much. Yeah, go ahead, state your name.
I'm Benjamin Katz. I'm the Commission's Assistant Counsel. And Senator Serville, to answer your question, and thank you, that is an issue that the Commission has wrestled with, and what I would suggest in response, certainly there are shades of gray between merely erring and committing ethical misconduct. And certainly playing out those shades of gray, gradations in the conduct, if you had a factual record that demonstrated a positive assertion from the judge that said, I recognize what I'm compelled to do by the law and I'm choosing not to do it, that would certainly push you toward the extreme of misconduct. If you had a pattern of behavior where a judge failed to apply the law as written, that would certainly push you to a gradation of ethical misconduct. But short of examples like that, it does represent a judgment call. Is this mere error or is this misconduct? And what I can tell you in response to your question is that that is an issue the commission is sensitive to. It wrestles with that, and it makes a determination based on the evidence before it. And I hope that answers your question, Senator.
Yeah,
I could,
go ahead.
if I
Go
could,
ahead.
if
Go
I
ahead.
could, thank you, sir. If I could follow, now, having listened to Benjamin, I do recall I was involved, well, I can't talk about facts of the case, so. I have seen that, and I presented it, and well, I can't say that either. Okay. If
What
I
can you
feel like a
say?
magician, Anyway, if I saw that, I would present it to the commission, and they would make a decision, and it's based on all the facts, and motivation sometimes are
If there are no
involved, and
further
sometimes-
questions, if there are no further questions, thank you all very, very much for coming. We appreciate it very much.
Thank you, senators. Thank
Yeah,
you all.
Thank you.
Thank you.
Now, at this time, we're going to move forward to judicial certifications. On December the 9th, the House Judicial Panel and the Senate Judiciary Committee held hearings on incumbent judges to be reappointed to the Supreme Court of Virginia Supreme Court, the Court of Appeals, the Circuit Courts, the General District Courts, and the Juvenile Domestic Relations District Courts, 2 Judicial Interim Review Commission members, and 2 judicial candidates. A list of the names and the vacancies for which they are being considered has been distributed to each of you. Please take a minute to review the list. The committee will take up the names in a block and will operate by voice vote. If any member wishes to remove a candidate from the block and vote separately, please do so at this time. Now, the chair will entertain a motion to certify these candidates: Supreme Court of Virginia, Court of Appeals of Virginia, Circuit Court judges, the
Chair, I
General District Court and Juvenile Domestic Relations District Court, 2 jerk members and 2 judicial candidates.
Mr. Chair, I have a motion. I move that we certify these candidates as qualified for the respective judgeships as listed.
Is there a second?
Mr. Chair, are you doing that? Our question for
Yes, go ahead.
Co-Chair. Senator Deeds, is that for all 4 courts at once? Or are you doing it individually? The Supreme?
I was making a motion for all of the courts and the jerk members.
When it's appropriate, Mr. Chair, I want to remove 1 from the block from the
Okay.
Then I withdraw the
juvenile
motion.
domestic relations.
Okay. Withdraw the motion. Want to make another motion?
I withdraw the motion. I withdraw the motion until Senator Morrissey makes his motion.
Thank you, Mr. Chair. On the respective juvenile and domestic relations court, please remove the Honorable Shannon Hoehl of Hanover. Thank you.
Okay. Anybody else want to remove a name from the block?
Mr. Chairman,
Yes.
we are going to take that name up individually as, after we vote on the block, correct?
Okay. We can. All right, yeah, we can. All right, other than that one name, Senator Deeds, would you like to make a motion?
I'll make a motion that the remaining names be certified as qualified for their respective judgeships as listed.
Okay, is there a second? Second. Been moved and seconded that the judges on the list, except for that one name, shall be certified as qualified to sit on the respective courts. All in favor of the motion, vote aye. All opposed, no. Aye. Voice vote. Aye. The motion carries. Okay?
Mr. Chairman,
Yes, Senator
I move to
Hanover.
certify,
McDougal.
I move to certify the Honorable Shannon D. Hoyle of Hanover.
Mr. Chair.
It's been moved and seconded
Mr. Chair,
certify
speaking
the
to that motion,
Yes.
it's been our normal procedure that when individuals have been removed from the block, there's not a vote on that person right away. I was hoping to not go into it in detail, but I'll tell the committee that I've received multiple complaints from multiple NAACP organizations about Judge Hoyle's demeanor and attitude. Those people have an opportunity to speak, and this is just the beginning of the General Assembly. I brought it to the attention of Senator McDougal earlier that there were multiple complaints, so until this body has been made aware of what those are, I don't think we should take a vote at this time.
Mr. Chairman,
Senator McDougal.
Mr. Chairman, many of us were at the December 9th hearing when Judge Hoyle was there. Nobody spoke against her. I've received 0 complaints whatsoever, and certainly Senator Morrissey at an event in Henrico did mention that he had some concerns, did not specify that they were related to any group. As of this meeting right now, I've heard no complaints whatsoever from any group that Senator Morrissey articulated. And I don't think it's been the policy of this committee to, if a member asks that somebody be removed, that there not be a vote after that. If Senator Morrissey wishes to vote against the motion, then he's certainly capable of doing that.
Mr. Chair.
Senator Morrissey.
I have not been on Judiciary as long as Senator McDougal, but in the 3.5 years that I've been here, when an individual has been removed from the block, there was no vote that immediately following it. I know that there is a request to the JUR committee for complaints about Judge Hoyle. I know that there are numerous people, organizations that want to voice their sentiments, and I think in the nature of full transparency, that we ought to do that and not rush a certification through right now. Let me present the information to Senator McDougal, and let's present it to this body and decide if that person should be reappointed.
Put this off for a week?
Mr. Chairman, no. I mean, if you want to put off all the rest of them for a week, that's fine too. But this is the normal practice. We've been here. I was here on the 9th. We had a discussion. We've been here all week. This certainly could have been presented before today. Everybody has the ability to vote their conscience. Made a motion. It's been second.
Okay, we have a motion in front of us. We operate by motion. And the motion is to certify the judge? And be motion second. Okay, all in favor of the motion to certify?
Has there been a second, Mr. Chair?
Judge, what's her name? Judge Shannon Hoyle of Hanover County as a judge of the Juvenile Domestic Relations District Court. Are you ready to vote? All in favor of the motion, vote aye. Aye. All opposed?
No.
No. Okay. The motion carries. Okay. All right, thank you. Now we move on. I think we've taken care of the judges, right, Shannon? At this time, since everybody's here, I'd like to ask the members of the committee, going from left to right, to explain, say who you are and where you represent, what district you represent. Going, Senator McDougal, going from left to right. Go right across, and then we'll go to the next table.
Thank you, Mr. Chairman. Senator Obenshain and I were chatting back here. So Ryan McDougal from Hanover, practicing attorney, former prosecutor.
Mark Obenshain, Senate District 26, Shenandoah Valley.
Tommy Norman, Senate District, current Senate District number 3, Historic Triangle area of Virginia.
Cree Deeds, current Senate District 25.
John Edwards, my Senate district is 21st Senate District, the Roanoke Valley and the New River Valley, including Virginia Tech. You probably heard that.
Dick Saslaw, current 35th District, which is mostly inside the Beltway, one or two precincts outside City of Falls Church and the west end of the city of Alexandria.
L. Louise Lucas, 18 Senatorial District. I know you hear this every year. Portsmouth, Chesapeake, Suffolk, Franklin, Southampton County, Isle of Wight County, Greensville County, Brunswick County, and a couple of other localities west. That's the current 18. The new 18 will be different.
All right, Chap Peterson, my wife and I own a law practice in Fairfax City. I represent Fairfax City, town of Vienna, and currently heading out towards Centerville.
Scott Survell, the 36th Senate District, and I used to own a law practice with Senator Peterson.
Thank you, Mr. Chair. Good morning, folks. My name is Joe Morrissey. I represent a large swath of Central Virginia, including Richmond, Petersburg, Hopewell, Prince George, Dinwiddie.
Good morning. I'm Senator Jennifer Boysko, representing the current 33rd Senate District, which is Eastern Loudoun County, Northwestern Fairfax County, and I do not have a law practice.
Jennifer McClellan, representing Senate District 9, which you're in, so welcome. Parts of the city of Richmond, Henrico County, the town of Ashland, all of Charles City County, and I am also a lawyer.
Yeah. Senator Stewart.
You can see I was paying attention. Richard Stewart from the 28th Senate District, which is part of Westmoreland, part of King George, part of Spotsylvania, part of Stafford, and part of Prince William.
Bill Stanley, in my other life, I'm an attorney in beautiful Southside and Southwest Virginia, and I represent Southside, Southwest Virginia, and all of the state of North Carolina.
Mark Peak, also a lawyer in Lynchburg, Virginia, 22nd Senate District, Lynchburg to Goochland.
Okay. Thank you all. So everybody knows who everybody is. The next thing we're going to do is to re-refer certain committees to other committees. Senate Bill 901, Senator Morrison's bill, firearms and unattended motor vehicles and civil penalty. This will be re-referred to the Senate Committee on Transportation. Is there a motion? Do we have to go on the board? Okay, go on the board.
Ayes 11, noes 4.
Okay. The next bill would be re-referred to the Senate Commerce and Labor Committee, Senator McPike's bill, Senate Bill 1040. And all in favor of the motion, vote aye. All opposed, no.
Ayes 15, no 0.
Did I say? Okay. And Senate Bill, Senator Peake's bill is to be re-referred to the Education and Health Committee. Is there a second? Is there a second? All in favor of the motion to re-refer it to the Education and Health Committee, Senator Peake's bill, Senate Bill 1054, vote aye. All opposed, no. Vote no.
Ayes 15, no 0.
Okay. All right. Now, we have a series of bills to be re-referred to the Civil Subcommittee. Yeah. We don't need to vote on this, but Senator Peterson's bill committee, the Civil Law Subcommittee, Senator Peterson's bill, Senate Bill 810, Senator Peterson's bill, Senator 811, Senator Serval's bill, Senator Bill 817, Senator Serval's bill, Senator 895. They used to practice law together, so maybe they can get along. So those committee, the subcommittee on civil law will receive and hear those bills. Now we have the committee agenda in front of us, and first of all, we can take up non-committee patrons. Senator Reeves, who's here, is Senate Bill 783.
Thank you, Mr. Chairman, members of the committee. You all have heard this bill before. You heard it in 2022. It came out of this committee unopposed and off the floor unopposed. It died in the House under Rob Bell. But what this bill does is, trying to get it through the Alamo. What this bill does is, we've set up the Veterans Treatment Court or docket. We have drug dockets, mental health, and there's an admin process that if you have 2 DUIs and you're facing a third, that you have an automatic revocation of your
Mr.
license.
Chair, Senator Reeves, is this different at all from the bill that you had last year?
There's a couple technical
Okay.
changes, but compared to last year, we're hoping this will work. It gives that authority to the judges. If you read it, it's in that second paragraph. It talks about giving the judge the authority. It's an 18-month-long program, Veterans Court. And so what happens, Mr. Chair, is that if I have 2 DUIs, I go into this process, I spend 18 months, I need to get a job, but I can't get my license back. They're probably not going to try to go through the docket. So we're trying to get that through to allow our judges the ability to use their discretion from the bench to make sure that these folks have an opportunity to drive.
Mr. Chair, this is a bill that got out of this committee last year, 15-0. The technical changes seem to me to tighten the bill up. So I would move that we report the bill.
Second. All in favor of the motion of reporting Senate Bill 783, vote aye. All opposed, vote no.
Thank you, Mr. Chair.
Congratulations, Senator.
Ayes 15, no zero.
Okay, Senator Locke has a bill, Senate Bill 784, Judicial Retirement System. Senator Locke, welcome.
Thank you, Mr. Chairman. One of the joys of my life is not appearing in the judiciary, but here I am.
You're not a lawyer, is that it?
Okay, there is a substitute.
Okay, is a substitute?
I move we adopt the substitute.
Second?
All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Motion carries. So what's the difference between the substitute and the original bill?
The word "or" instead of "and."
Or, are you sure you want to debate
On line
that?
26.
Okay. No more or. Line 26. Okay. The retired justice or judge is at least 67 years of age and is eligible to receive full Social Security benefits. That has to do with,
Okay. Mr. Chairman, what the current law says is that if a judge can leave the bench and work somewhere else, but they cannot appear in court. In other words, if a judge leaves the bench and want to practice law, even on a limited basis until they die, they can never see a dime of their pension. So basically, the new condition is that there's a second avenue to qualify for the judge to appear as a counsel, and is separate from the other existing 4 conditions of the current law. This would allow justices and judges who do not meet the first 4 requirements of the law, but who are at least 67 years and eligible for Social Security benefits to appear as counsel in a case before a court of the Commonwealth. The initial draft had the word "and" on line 26, but that has been changed to "or" before Romanet 5, which is why there's a substitute.
okay.
Mr.
Any
Chair.
questions of the patrons?
Mr. Chairman.
Yeah, Senator Obenchain.
For patron or counsel, would these retired judges who are appearing in tribunals also be permitted to serve as on the recall list?
It can't be.
Anybody have an answer to that?
I don't see a disqualification in here.
Charles?
Thank you, Mr. Chair. I think,
Senator Morrissey.
follow-up to Senator Obenstein's question. Senator,
An
the
answer
genesis.
first?
Well, I was going to, certainly.
Does anybody have an answer to the question?
Just a second.
Go ahead.
Senator Morrissey, do you have an answer?
Well,
Senator
hang on.
Obenstein?
I think council's looking. If you could
Sure,
just
certainly.
indulge me for a second.
I think that's the point of the or.
Charles?
Mr. Chair, it looks like the restriction of not authorizing only applies to the subsection or the Clause A, so that would need to be added in to the additional clause.
And perhaps, Mr. Chairman, the
Yeah,
place to do
Steve
that would be
Benjamin.
on line 27 and insert a clause after the word benefits, beginning with the word provided that. And so if you like the concept, then we could come up with the language.
Would that permanently prohibit? So it just, I think part of the theory is that once you are, when you are serving as a judge, you shouldn't be appearing as counsel. And if you're going to be serving as a judge at some point, maybe 6 months or a year later, that's maybe chilling to counsel in the case in which that judge is appearing.
Yeah, Senator Morrissey.
This is, Senator, I'm interested in your thoughts because you're the sponsor of the bill, but as a follow-up to Senator Obenschein, the genesis of this bill was that, for example, a circuit court judge retires, and they felt, let's say, under 67.
Ever.
And that judge is prohibited from serving, going into the court, practicing as an attorney, because there was a feeling that perhaps there would be some undue influence of that individual appearing as counsel before a general district court judge or another member of another colleague that he was serving with a few years before. I can understand that. I'm curious about this bill. Would your bill require, or do you feel it should require, if that 67-plus year retired judge, that if he did represent clients in court, that he not be subject to recall? Is that your thinking and your desire? That's my first question.
This was brought to me by a former judge who simply wants to practice law, but is not entitled to a pension because the former judge wants to practice law. Does not want to be a judge anymore, but simply wants to practice law.
Mr. Chairman.
And as a consequence, is not entitled to a pension.
Follow-up question.
Senator Morrissey.
I think there may be greater merit to your bill, and it would assuage Senator Obenschein and perhaps others if we knew that that 67-plus year judge was not going to be subject to recall as a substitute judge. That's just my thought. Maybe we might want to continue over to address that point. But
Mr. Chair.
Senator Obenschein.
Would it not solve this problem to reinsert and?
No, Mr. Chair.
Yeah. Senator
Chair.
McClellan.
The and issue was a problem for VRS.
Mr. Chair, the language that you need for the new language being pulled in by Senator Locke's bill is already in little I. So what you need to do is combine the new language with an or with the existing language in little I by either pulling the new language up into little I or pulling little I down into the new language. But the point is, if you are a retired judge who is practicing, you shouldn't be subject to recall. We already provide for that in one section of the bill. All we need to do is draft this bill in a way that preserves that for the new section.
Okay, yeah, Senator Obenschein.
Okay.
We have an amendment or not?
So, Mr. Chair,
Senator Peterson.
just to summarize, I think we're all in favor of the bill that a retired judge should be allowed to practice as long as we know they're not going back on the bench, either in a substitute or a retired judge capacity. So we just need somebody to write that.
Okay, you working on an amendment, Steve?
I think if we take either out, and then bring that down to, right, here, right? This is.
Wiser heads than mine.
Yeah, I think so.
Mr. Chair, I'm going to move that this go by for the day to allow staff to draft a new substitute that captures the concept that we have been talking about.
Okay, without objection, your simple bill will go by for the day.
Works for me.
Okay, thank you very much. Senator Sproul, Senate Bill 789 increases the jury duty allowance from $30 to $100 a day.
Yes. Good morning, Mr. Chairman and members.
Yeah. Go ahead, Senator Sproul.
Mr. Chairman, this legislation would increase the compensation for jury duty from the current $30 to $100 for an 8-hour day work. $30 come out to be $3.75 per hour. Some courts have an issue with getting people showing up for jury duty. Many times it is because they cannot afford to come to jury duty and lose job and work. Increasing to $100 would bring the rate to $12.50 an hour for an 8-hour day and would expand the base of people who would participate in the civil duties. We should not make people choose between a meal on the table of the jurors. This rate has not been increased since over 30 years. And the price some lawyers charge, they really shouldn't have no problem with this. I talked with the Commonwealth attorneys, the judges, and the sheriff in Hampton Roads. They agree that they're having problems. People are making all kinds of excuses to not participate in jury duty because if, for example, if I make $85 a day, you're going to come in and make $30 a day, and my job won't pay me.
Mr. Chair,
Yeah, Senator Peterson.
how about we just give them a percentage of the verdict? Then we all make money.
That's true.
Okay.
So all I'm trying to do, Mr. Chairman, is saying that we are trying to get more people to participate in the jury process and those who are more qualified. And we're talking about over 30 years for $30 a day. And that's the problem they have, and people make up all kinds of excuses why they cannot participate because they cannot afford to get off or won't get off for $30 a day. So I'm asking you to make it $100 a day, which comes to $12.50 an hour.
Mr. Chair,
Yeah, Senator Morrissey.
this bill is long overdue. Individuals that are working, a single mother is making $15 an hour. Often, Mr. Chair, if she comes down to court, she will not be paid her other salary, and if she doesn't appear in court, a contempt of court will be issued for her. So, and then there's other people that they don't need the money. So I think the people that are most affected are poor individuals, and I applaud the senator for bringing this long overdue measure. And at the appropriate time, I'd like to make a motion.
Okay. Any further discussion?
Mr. Chair,
Yeah,
we
Senator
passed
Deeds.
this bill last year, 15-0. We sent it it goes to the Finance Committee. I think it was cut to $50 a day. And then $50, and it was killed in the House. But I think your motion's appropriate.
Move to report, Mr. Chair.
It's been moved. Is there a second to the motion?
Second.
The report. Any discussion? All,
And re-refer to finance, Mr. Chair.
yeah, re-refer to finance. All in favor of the motion to report and re-refer to finance, vote aye. All opposed, no. Vote, you got to vote. Vote aye or vote no. Motion carries unanimously.
Ayes 15, no zero.
See you in finance.
Mr. Chairman, can it bypass finance?
I don't have that authority.
Senator Dunava's on the way. So
Yeah, okay. All right, Senator. All right, we're moving on then. We have a series of bills that we go by for the week. Senator Cosgrove is not here. That's Senate Bill 857, theft of or trafficking trade secrets. Senate Bill 858, evidence of defendant's mental condition, et cetera. Senate Bill 921, sex offenses prohibiting proximity to children, et cetera. Those three bills, 857, 858, and 921 of Senator Cosgrove will go by for the week at his request since he's not here. Moving on to patron. Yeah. Patron bills.
She's on the way.
Okay, yeah, Senator Donovan's on her way. We'll move forward to Senator Serval's bill, 4 bills. He likes to have a lot of bills. Senator Serval. Senate Bill 799, evidence of medical reports. And I think this is the same as it happened, this is for the juvenile court, but the same thing happens in the general district court. Is that right?
That's correct, Your Honor.
Okay.
Mr. Chairman, I have a quick line amendment.
Okay. Go ahead.
So while he's passing that out, basically this is a bill the Family Law Coalition came up with to sort of parrot in juvenile and domestic relations court what we already do in general district court. You all may be aware that since like about 1978, you can present medical testimony in general district court by affidavit as long as you do it a certain number of days before trial. Right now in juvenile court, you can only do that in protective order proceedings or for child abuse and neglect cases. But you cannot do it in child custody, visitation, or support cases. And so basically this bill does the same thing you can in general district court with a couple tweaks. Number one, instead of 10 days notice, it requires 30 days notice. Because if you're talking about sort of child therapist testimony, it takes a little bit more time to get a response prepared to that than like five or 10 days. And it does not apply on appeal in the circuit court. Those are basically the two differences that it has with between how it works in general district court versus juvenile court. And this will go a long way towards helping people introduce sort of mental health therapist testimony in child custody and visitation cases. Right now, it's in the limited time you have in juvenile court, it's often very hard to do that. And Mr. Chairman, I have this line amendment. These line amendments I'd like to move, and I can explain those.
Is it moved? Is it moved?
I'll move the amendments,
And
yeah.
seconded. All in favor of the line amendment, say aye. Aye. All opposed, no. Motion carries.
The line amendments just make it clear that you can also do this in a spousal support case, and it removes any reference to depositions because there are no depositions in juvenile court.
Okay, Senator Deeds? Senator Norman.
Mr. Chairman, a question. Because the report is being provided in advance, it does not preclude attorneys from subpoenaing the medical person if they so choose. Is that correct?
Correct, and that's why I put a 30-day trigger on it, because I wanted to have enough time for that to play out. And I think it's very different in a child custody or visitation case than a personal injury case.
Okay, any other questions?
But, Mr. Chairman.
Yeah, Senator McDougal?
Then if I'm reading the last end, if this has to be provided within 30 days, but you only have 15 days to respond. So if this report is provided, then you have to have your response submitted within 15 days of court. So it's really only a 15-day notice, it's not a 30-day notice.
Well, the person who intends to start the process of using the testimony has to give at least 30 days notice, and then the other party has 15 days. They can go call that provider and try and get them to write a clarifying report or clarifying information, or subpoena them to court. But if they want to do a counter designation or a counter report, they have to do that within 15 days.
Okay, any other questions? Okay,
I think there's the Family Law Coalition supports it. They're here.
Family Law Coalition, like to speak? Okay.
Mr. Chairman, Dan Gray on behalf of the Virginia Family Law Coalition. We support the bill and we appreciate the senator introducing it.
Okay, thank you. Next.
Thank you, Mr. Chair and members of the committee. Valerie LaRue from Virginia Poverty Law Center. We also support the bill. However, we like the House version better. The House version carried by Delegate Campbell would give 10 days rather than 30 days. And that would be more in line with the existing self-authenticating statutes like 8.01 390.1, 8.01 390.3, which have 15 and 7 days respectively, 16.1 88.2, and 16.1 245.1, both of which have 10 days. So we just ask that the committee consider keeping it in line with the other statutes that are similar.
Mr. Chair. Valerie, what would you do then with the 15-day notice on
So the Senator Delegate Campbell's bill does not have the 15-day requirement, so somebody could object contemporaneously in court.
Okay.
Mr. Chair.
Yeah, Senator Peterson.
Peterson?
You.
Yeah, Scott, just so I understand, basically, this is an exception to the hearsay rule, so it's the ability to use a report in lieu of live testimony.
Right.
Okay,
Just
so
like
basically, it's a question of if you submit a report and say, I'm going to submit this report, does your opponent have an opportunity to go out and get their own expert and have a counter report?
That's what my bill does, and that's why I have the broader time
Right,
frame
I get
than
it.
personal injury case.
Okay.
Same thing happens in general district court. Okay.
Right.
All right, okay.
Move to report as amended.
Next, somebody else want to speak?
Mr. Chairman, Eric Link on behalf of the VBA, we support the bill.
Okay.
Move to report as amended, Mr. Chair.
Been moved and seconded to report the bill as amended. All in favor of the motion, vote aye. All opposed, no. Okay, 15-0. The
Ayes
motion
15, no zero.
carries. All right, thank you. Next bill, Senate Bill 801.
Thank you, Mr. Chairman.
Conservators of the peace.
So 801 just adds the United States Army Criminal Investigation Division and the Air Force Criminal Investigation to both the Investigation Division to the Conservative of the Peace statute and also the statute regarding the service of search warrants. This was brought to my attention by the military police at Fort Belvoir when they were trying to investigate a stalking case where some of the stalking behavior occurred on base, and they wanted to serve a search warrant off base, and they discovered that under our statute, Naval Criminal Investigation Division is authorized to do it, but not Army Criminal Investigation is authorized. And so this bill just basically cleans it up and puts all of the military criminal investigation divisions in the same posture.
Well, it used to be the NIS, Naval Investigative Service, by the way. As a former Marine Corps JAG officer, I can tell you that's what it used to be. I don't know when they changed the name. Is there any other military
Air Force.
investigative? Yeah, Army and Air Force, but is it another investigation of the military at all? Okay.
No, because Navy covers the Marines too, and I don't think the Space Force has their own yet.
Mr. Chair,
Yeah, Senator Sherrill.
question for the
Peterson.
patron.
Uh-huh.
Senator Morrissey.
Scott, do you distinguish in your bill the ability for this individual to serve a search warrant as opposed to apply or be an affiant for a search warrant?
No, I think this just, if you look at the bill, there's a whole list of different agencies that are authorized to execute search warrants, like FBI, DEA, BATF, et cetera, and this adds, there was already the Naval Criminal Investigation Services in there. This just adds Army and Air Force.
Follow-up question.
Yeah, Senator Morrissey.
Your bill still requires that this individual serve the search warrant with a Virginia law enforcement officer. So respectfully, why do we even need this bill? If you have a law enforcement officer serving and executing the search warrant, you can have 16 different people going with them. Why do we have to have a legislation to allow this individual to go with a law enforcement officer who is serving a warrant?
Mr. Chairman, all I can tell Senator Morrissey is that the Army Criminal Investigation Division wanted to be in the same posture as the Naval Criminal Investigation Division. And it's already, that sort of precedent was already set.
I just wanted to see if I was missing anything. All right, thanks, Scott.
Any further discussion? All in favor of the motion to report the bill, vote aye. All opposed, no.
Ayes 15, no zero.
Motion carries. Okay, Senator Sherrill, you have
814.
814.
And I have a substitute for that.
Interpreters for the deaf. Okay. It's been moved. Is there a second?
Second.
Moved and second to adopt the substitute. All in favor say aye. Aye. All opposed, no. Motion carries. Okay, interpreters for the deaf.
Thank you, Mr. Chairman. So this bill was brought to my attention by the Fairfax County Circuit Court. They've been having a really hard time getting interpreters for deaf and hard of hearing post-pandemic, and they were looking to sort of broaden the list of people that they could use. Right now, they're only allowed to utilize an interpreter that's been procured by the Supreme Court of Virginia. And anyway, the bill has generated some, and there's some folks here that, I don't know if there's somebody signing for them so they can hear what or understand what I'm saying.
Mr. Chair, I would just be interested in knowing whether if the Supreme Court thinks that there's a reason for them to be the only group that certifies.
Well, what I would say, Mr. Chairman, is that the Supreme Court was fine with the bill, but the Virginia Department for the Deaf and Hard of Hearing had some issues with the bill, which is what the substitute deals with. They still want to have some say in who is selected, because apparently there are different gradations of sign interpretations. There's some that just do theater or school, and whereas legal is like this higher classification, they want to make sure people are qualified. And so the amendment that's in front of you gives the department sort of a veto over people that the county, the circuit court procures if the state is unable to provide somebody. They're hopeful that this will solve the problem. Apparently, they're also in the process of hiring 4 state interpreters, 2 of which will be assigned to Northern Virginia to help with the problem they have on volume. And anyway, I think with the amendment, there's now peace in the valley on this, and there's some people here that might
Anybody
stand up
want
and
to speak in favor of the bill or against the bill? Anybody here?
I guess they're okay now.
Move to report. Is there a second? All in favor of the motion to report the substitute, vote aye. All opposed, no. Vote no.
Ayes 15, no zero.
Okay. Senator Server, you're on a roll.
Thanks. Yeah, this one's a little more complicated.
835, prohibited sales and loans to juveniles.
I don't know if Senator Donovan has the version of this bill. I don't know. Is she here?
Senator Donovan's on the way. You want to wait until she gets here and do that?
Yeah, we ought to do them at the same time.
You all have dual bills.
Yeah, differing approaches. Yeah. Yeah, okay.
All right, moving forward to Senator Peterson has Senate Bill 812 dealing with emergency relief payments. Senator Peterson, you want to present the bill?
Thank you, Mr. Chair, and I think I can probably do this from my seat. This was a bill that was passed, or excuse me, a law that was passed in 2020, had to do with emergency relief payments that were authorized under the congressional acts back in 2020, COVID relief payments. Those payments have basically run their course. I don't think they've been issued for the past 18 to 24 months. And they were an exception to the garnishment rules. In other words, if you received that payment, it would not be garnished. But again, those payments have run their course. And so this was a request from the Bankers Association that this basically is one less thing that they don't have to check off on when they respond to a garnishment. So if they're responding to a garnishment, that they don't have to certify that the money in the account or the payment is part of the relief funds that were distributed in 2020. So I don't know if Matt Brunin is here from the Bankers. There he is.
Okay, Matt.
So I'll call him forward to be my witness.
Bankers Association.
Thank you, Mr. Chairman, members of the committee. Matt Bruning with the Virginia Bankers Association. We appreciate Senator Peterson putting in this bill. He's kind of covered everything. We put this in, worked with then Attorney General Herring's office to get those protections. We had hoped it would be done at the federal level. We were able to put those in for the CARES Act and the other, emergency federal stimulus that was sent out during the pandemic. Now that we've kind of moved past those payments going out, if you can see, you can look down at the section of the code that we're repealing. It is a rather cumbersome process, and we want to be able to just move on from having to go back and do those look backs. So we support the bill.
Okay. Any questions? Anybody else would like to speak one way or the other? Is there a motion? Second. Moved and second to report the bill. Senate Bill 812. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no zero.
Okay, motion carries 15-0. Thank you. The next bill of Senator Peterson is going by for the week, I believe, as I understand it. Senate Bill 842, a petition to modify sentencing. Put it by for the week. Is that right, Senator
Yes,
Peterson?
sir. Yes,
Okay.
with your indulgence.
All right, and moving on to Senator Stanley. Where's Senator Stanley? He's not. The number of judges.
Do you want to take that up without him here? We can, because this was recommended by the Committee on District Courts. It simply adds an additional district court judge in the Danville, Pennsylvania, Franklin County Circuit.
I'm very familiar with that district. And
And this has to go to finance, Mr. Chair.
I'm sorry.
This has to go to finance, Mr. Chair.
Yeah, good.
Okay, move the report and we refer to finance.
Okay, moved and seconded to report and re-refer to finance. All in favor of Senate Bill 816, vote aye. Report and re-refer to finance. All in favor of the motion, vote aye. All opposed, no.
And we ought to mark this one on the wall. This
Ayes
is a new one
15,
that
no
doesn't
zero.
go to Northern Virginia. This is a new judge that doesn't go to Northern Virginia. So put it on the wall, mark it on the wall.
Okay, the motion carries, so the bill has been reported and re-referred to finance. Senator McDougal, you have a family abuse protective order. It's Senate Bill 873.
Thank you, Mr. Chairman. Mr. Chairman, we have a substitute that Mr. Quagliato, or
Mr. Chair, I have
maybe.
2 line amendments to this bill. I can read the line amendments. The first one is on line 109, after the word minor, insert, and an emergency protective order was issued pursuant to 16.1, 253.4 for the protection of such minor. And then after friend on line 110, insert before such emergency protective order expires or within 24 hours of the expiration of such emergency protective order.
Mr. Chairman, I move those amendments.
Okay, is there a second? All in favor of the amendment, say aye. Aye, all opposed, no. The motion carries.
Mr. Chairman, tell the example, Mr. Quagliato got this call from me one Friday afternoon, I think at about 4 or 4:30. Prosecutor came up with a situation where a juvenile had been the victim of family violence. The individual, they thought at that time, was going to get out on bond. The emergency protective order had been issued pursuant to the original criminal charge, but the family member was, because they were subject to the criminal charge, was refusing to be the individual that would go forward for the emergency protective order. So the juvenile was going to be left with no protection. So Mr. Quagliato looked at that. We were for about 30 minutes trying to find another way. We couldn't find another way. And in essence, what the code currently says is that law enforcement can ask for the EPO and magistrate grant it if it's the emergency protective order, but then the preliminary protective order, it has to be the next friend. And the next friend is the closest, has been historically determined as a parent or somebody standing in that role. Now, some individuals came by, the Attorney General, which was then Cuccinelli, issued an opinion back in 2011 talking about the same issue. Delegate Herring had requested it. And at the end of it, the Attorney General indicated the same thing, that the law enforcement can ask for an emergency protective order, but there's no provision for them to ask as next friend for the preliminary protective order. So this just gets in that emergency time frame. So as the math goes forward, there's 3 days or the next day court is in session for emergency protective order, and then the preliminary protective order is 14 days. So this is just that immediate time and not past that.
Mr. Chairman.
Yeah, Senator, who?
Surville.
Senator
Thanks.
Surville.
Senator, it's an interesting fact pattern. I know the Commonwealth attorneys have that one statute that says the things they're allowed to do, felonies and misdemeanors by option, and we had to add, for example, civil refusal to it a few years ago because they weren't allowed to enter an appearance in civil refusal cases. And I guess this is a different way of adding to that statute, but this only covers preliminary protective orders. Who represents this child at the actual hearing for the permanent order? Because it doesn't seem to talk about that here.
Mr. Chairman, at that point in time, the hope is that the court would then appoint a guardian ad litem to represent the child. The problem is, at that emergency protective order, oftentimes it's happening on a weekend, or as this was the case, Friday afternoon, when there's usually very few people around the courthouse to be able to get a guardian in to file that. So this just allows that time to then the court to appoint a person who would stand in local parentis or next of kin to file those motions.
Yeah, Senator Surville.
So, yeah, thanks. So it's specifically your intent that the Commonwealth attorney and the officer would not be involved presenting evidence at the permanent protective order hearing?
Mr. Chairman, yes, this is just to allow the situation for the court to be able to
Get it
protect
started.
the child in that quick time frame. And I think that's what we originally thought with the EPOs, but it's hard to think of the thought pattern where that parent is the one actually charged with the criminal offense. And this is limited, it is just to the cases where the EPO follows a criminal charge. I'm not trying to cover the whole world, just this specific situation.
Mr. Chairman?
Okay, Senator Sherrill.
Thanks. Okay, well, I understand that part now. One other question is, I mean, normally when you're talking about abuse and neglect cases, those are initiated, pushed by, I guess, DSS caseworkers, and so I'm curious why, like, they wouldn't be the more appropriate person to press it as opposed to the Commonwealth Attorney or a law enforcement officer, or why they're not on the Christmas tree list you got here?
Mr. Chairman, what has happened, I guess, and maybe this is not the case in all jurisdictions, is on some of these criminal charges, DSS's process takes longer than those 3 days to go through for them to make a determination. So they're saying, we're not getting involved. At some point in history, they used to be involved at this, but I think with their staffing, it's too quick. And that's why I'm trying to limit it to the very short time frame in the short situation where there's a criminal charge and the protective order needs to be extended.
I got it. Thank you.
Okay. Any other questions? Okay.
I've got a question, Mr.
Senator
Chair.
Deeds.
Wouldn't the Commonwealth Attorney have a conflict of interest? I mean, we're from representing the victim and also prosecuting the crime?
Mr. Chairman, I don't think that is the case because they were still working with the victim. If the committee feels more comfortable with it just being law enforcement officer, I'm fine with that. I'm just trying to, the situation typically comes up because there's some sort of bond determination, and that's when it becomes apparent that the person who's been charged with the criminal offense is also the one that would be able to make the determination about whether to file the protective order for the protection of the juvenile. So, if the committee feels better with it just being law enforcement officer, I'm fine with that. I'm just trying to make sure there is a person in the stream, because right now it doesn't seem to be any physical mechanism for there to be the filing of for the preliminary protective order if there is a situation where the person charged with the crime would be subject to the protective order.
Well, Mr. Chair,
Yes, Senator Deeds.
what if we just replace the Department of Social Services for Commonwealth Attorney or law enforcement officer? So you've got somebody completely out of the prosecution of the crime.
Mr. Chairman, again, my experience has been, and this experience was, that Department of Social Services is not, because of staffing or whatever, frequently in that emergency time, that 3 days, able to come in and make the determination. Otherwise, they'd be taking the child and placing them somewhere else, but it's not happening in those 3 days. So I'm just trying to do that delta between those 3 days, which again frequently happens over a weekend. So if there's an event that occurs on a Friday evening, this is coming up in court on Monday, and and that protective order expires by midnight on Monday, and DSS oftentimes has not been able to do an investigation. I'm just trying to get the PPO filed, and then there are a lot of avenues that the court can take up. In addition, DSS appointing a guardian ad litem, which could then file on behalf of the juvenile, but that 3-day problem is becoming an issue. It didn't happen, this has happened in some jurisdictions multiple times. That's why it resulted in the bill. First time I got a call, we didn't do the bill. Once I got it, multiple times we did.
Any other questions? Okay. Is there a motion of any sort? It's moved to report and it's seconded. All in favor of the motion, vote aye. All opposed, vote no.
Can you vote mine and my proxies? Mr. Chairman, I think I have 2 proxies too.
Two proxies?
It's not, I don't have it up. Just press it.
Sorry, it's
Oh, we got it.
ayes 14, no zero, abstentions 1.
Okay. Senate Bill 881, Senator McDougal, that felony homicide. I understand you have a witness.
Yes, Mr. Chairman, I have witnessed, and I have some sheets to hand out to the committee.
Okay. Senate Bill 881.
Mr. Chairman, this is not the first time that this committee has seen this piece of legislation. Back in 2019, the committee, well, the Senate and the House passed similar legislation. I didn't check it to make sure it's word for word, but I think it is the same bill. And it went to the governor and was ultimately vetoed. And this deals with the situation that came about in 2012. The committee remembers there was a case called Woodard. At that point in time, there was the thought process that if you were dealing drugs, and if you dealt that drug to an individual that took the drug and they died, that you could be charged with felony homicide. Woodard case went forward and in essence said that there has to be time, place restrictions on that, that if you deal the drugs and the person takes them in your presence and dies, then you could be convicted of felony homicide. But if you dealt drugs, the person took them with them and went to another place and took the drugs and died, then there was not a crime for felony homicide. Mr. Chairman, as you look through that, I don't believe, and I think most prosecutors, and you can ask them here, don't also believe that that meets the definition of involuntary manslaughter as well. So, Mr. Chairman, bill came forward, went through this body, and at that point in time, we saw that there was a significant uptick in people dying from overdosing from drugs. But in the last 3 years, and those are the numbers that I passed out to the committee, it's been just astronomical. Each of the last 3 years, the number of individuals in Virginia that are dying from, or the number of individuals that are dying from overdosing on drugs exceed the number of individuals that die in motor vehicle accidents and gun-related accidents or intentional combined. There are more people dying from overdosing of drugs than those combined. Just think about it. Last year, there were over 2,600 people that died from drug overdoses. And right now, there's no way for prosecutors to prosecute those. And this will make sure that the people dealing those illegal drugs, if there is a fatality that's associated with it, there's a proximate cause to the use of the drug, that there is a way for them to be punished. Mr. Chairman, this has had significant impact on a number of families, but there's one family here that wants to talk about their son and the loss that occurred to them as a result of them being passed a drug that resulted in their death.
Mr. Chair, can I ask the patron a question before we go to the two witnesses?
Senator Morsi.
Thank you, Mr. Chair. Ryan, we passed legislation, it's often referred to as the Good Samaritan Law, but there are other names, wherein an individual who is using an opioid, perhaps it's laced with fentanyl, which is the reason that we are having the spike, and the person goes into some type of distress, and that individual calls police, calls 911, that person won't be prosecuted. That legislation was passed by the entire General Assembly. It appears to me that with this bill, 881, if that individual did in fact share a drug with an individual who died, that the Good Samaritan Law would be negated and that person could be charged with felony homicide. That's my first question.
Mr. Chairman, and I don't have that statute right in front of me, so maybe Mr. Benjamin pulls it up, but I believe that Good Samaritan statute is for individuals won't be charged with possession of those drugs. Right now, under the current law, if you gave me a drug that had fentanyl, and my body reacted to it and I died, you could be charged with the felony homicide because you were in proximity to me, you provided the drug, and I died. The person that sold you the drug could not be prosecuted, but I think you can be today.
All right, let me pause and.
Mr. Chair.
Yeah, Senator, who was her?
Peterson.
Senator Peterson.
And I'm going to defer to Senator Benjamin, but I think that's just for misdemeanor possession. I don't think it is a felony distribution.
Mr. Chairman, I think if you have felony possession of drugs, so if you had a Schedule 1 or 2, that you're not prosecuted under the Good Samaritan law, but it's not distribution.
All right.
All right. Senator Morrissey?
I have a follow-up question, but let's let the chair, the
Senator.
Judiciary Council.
Senator Steve Benjamin.
And then
I'm still looking for the statute, if anybody has it.
It was 2021, 2020.
No, it'd be in the code.
Mr. Chairman, Mr. Nate Green, who's prosecutor in Williamsburg, might have some ability to.
Yeah, Williamsburg prosecutor. State your name.
Good morning, everyone. Nate Green, Commonwealth's attorney for the city of Williamsburg and James City County, and today I'm also here speaking on behalf of the Virginia Association of Commonwealth Attorneys. I can answer any questions, and I can state that Senator McDougal's comments about the restrictions on the Good Samaritan law as to felony possession is accurate. If you were a distributor, you could still be charged even if you were one to call. What we like to think about, there's really kind of three characters that get wrapped up in this. The first is a friend who goes to a hotel room and shares their heroin with their friend. They are, in fact, meeting the definition of distribution.
As an accommodation.
They could be charged with distributing it just by giving it to a friend. That individual they would have the accommodation reduction. And that individual could not be charged, could be charged with distribution, but if it was an accommodation, it would be reduced to a Class 5 felony. Senator McDougal's bill has the same protections for that individual who distributes drugs as an accommodation. And if the horrible thing happens and their friend were to pass, there is an accommodation reduction that would reduce it to the Class 5 felony and not the felony murder. The two individuals that are caught up in this are the two drug dealers. One who doesn't have many customers, and so when he shows up at the hotel room, he sells the heroin and then does a little bit with his customer. That individual today could be prosecuted for felony murder because of the time and the place in which he was found. If you're a heroin dealer that has a lot of customers and you don't have time to get to know them, and so all you do is show up at the hotel room, sell your heroin, and then beat feet and go sell it to the next guy, you've made enough distance in proximity and time that you could not be prosecuted for the felony murder. Why does this matter? If we could still get him for distribution, why do we care whether we could prosecute him for felony murder or not? We rely heavily on sentencing guidelines in Virginia. Judges rely heavily on sentencing guidelines in Virginia. If you were to be charged with distribution of heroin, your sentencing guidelines midpoint, the midpoint, would be 12 months. If you were to cooperate and plead guilty, your low end would be 0 because of the new rules on cooperation and showing remorse. That's what a drug dealer who has enough customers that he doesn't do drugs with his customers, but rather moves on. If he were to be found guilty of distributing drugs alone, his low end of his guidelines, if he pleads guilty, probably 0. If he doesn't plead guilty, go to trial, the midpoint's 1 year.
Mr. Chair, thank you for that, Nate. Right now, we all agree that the drug dealer, the really bad apple that gives heroin to an individual and then, as you say, goes on to make his next sale, existing law, and is not present when the person ingests the drug and dies, can be tried for felony murder. Okay.
No, that individual could not be. I'm sorry, I didn't mean to interrupt, Senator
No, you
Morrissey.
didn't. Go ahead.
That individual could not be, if he's not present when the individual uses the drugs and passes, he could not be prosecuted for felony murder.
Okay, so does Mr. Chair, so does Senator McDougal's bill allow that individual, the really bad apple, who distributes, leaves, and goes on to his next endeavor to be prosecuted for felony murder?
It does.
Okay, final question. Does this bill, though, exclude the individual who was present sharing his or her drugs with the other individual, and then that person takes an overdose? Is that person precluded from being prosecuted for felony murder, and may that person avail himself of or herself of the Good Samaritan law?
Mr. Chairman, Senator Morsi, if it was just simple possession at the same time, then yes, they could avail themselves of the Good Samaritan law. If they were the ones that brought the drugs and shared them, not as by means of profit, but just because we're buddies and today was my day to go get the drugs, technically that is still a distribution. Even when you give drugs without profiting from it, that's distribution, but there's an accommodation reduction that reduces it to a Class 5 felony. Senator McDougal's bill has the same reduction. If that individual was just there sharing with a friend, he would be charged with the Class 5 felony, but not the felony murder.
Final question.
I'm sorry, I believe I said that.
Senator Morsi.
Typical situation, an individual from VSU receives the drugs. They use it with another individual. They often go back to a dorm room and continue to share. Sadly, tragically, and increasingly, the drug is laced with a fentanyl component and the person dies. Down the line, when you're sharing and then sharing, can that person be charged under Senator McDougal's bill with felony homicide?
The individual that is present with the individual who passes, if they're there using the drugs with them, under current law, they right now could be charged with the felony murder because now we can prove the proximity in both time and place. This bill actually puts into law the accommodation of if you were there, but you weren't profiting, you were just there using with your friend, you are still accountable. You will still have some culpability, but it is limited to the Class 5 felony as opposed to felony murder or even the distribution.
Thank you very much.
Okay.
Mr. Chairman?
Yes, Steve Benjamin.
If I could ask Nate a question. Nate, and this may be what the patron intends, but I'd like your opinion on this. If person A sells undiluted heroin to person B, who then dilutes it or cuts it with fentanyl and then distributes it to person C, causing person C's death, it appears to me, but I'd like your opinion on it, that A, who just sold the unadulterated heroin, could be prosecuted for felony murder.
I don't believe so. Mr. Chairman, I believe because of the language, it has to be the drugs that you dealt, not that someone then alters and turns it into something different. Such controlled substance is the proximate cause of the death. I would argue that the controlled substance that person A sold wasn't the cause of the proximate death because someone altered it into something different than what they sold.
Mr. Chairman, if I could follow up.
Yes, Steve Benjamin.
I understand that makes sense, but if there's a death from an overdose and the person has taken heroin cut with fentanyl, I don't know that we would ever know whether it was the fentanyl that caused the death, would we?
Mr. Chairman, I'm actually in the middle of prosecuting one of these cases now, and that it actually is the issue. And I believe there is evidence that both sides are going to rely on from the medical examiner's report. There will be some testimony as to what in fact killed this person. Was it the cocaine? Was it the fentanyl? Was it her diabetes and being overweight? And there are going to be arguments as to what actually killed the person. And so this bill allows for, if the Commonwealth can prove that it was the proximate cause of the death was the drugs that you sold, then we can prove a felony murder. But if we cannot prove that, if we can't prove that it wasn't something possibly different, maybe the overconsumption of alcohol, well, then our evidence would fail, and while we may be able to try and prosecute the case, if the finding of fact was the drugs that were sold were not the proximate cause, then they couldn't be found guilty of the felony homicide. It's going to be a matter of proof.
And Mr. Chairman, I'll just
Yeah,
add.
Steve Benjamin.
If the patron wished to ensure that only the person directly distributing it to the deceased, the one who adds in, for example, the fentanyl, is subject to this, then alternative language could be inserted. But the patron may feel it's fine just as it is.
Mr. Chairman, I feel it's fine just as it is. I do think that the government is going to have to establish that those drugs are the proximate cause. And if somebody is used, there'll be a lot of different testimony that could be there, but certainly if somebody altered the drugs as they move through the process, then that would be a defense to the person that, hey, it wasn't the drugs I distributed that were the proximate cause of the death. I think there's, in two places, it says Schedule 1 or 2 to another person in violation, and such person's death results for the use of the controlled substance. So the death has to be the result of using the controlled substance that was distributed. So I do think that that is going to fall to the government as one of the elements of proof, and the defense is going to argue it wasn't the example that was just given, it wasn't the heroin, it was the fentanyl that was cut with the heroin that was the proximate cause.
Senator McDougal, the person involved could today be charged with distribution of drugs.
Mr. Chairman, just to be clear, if the individuals are using the drugs together or the drugs are used at the time of the distribution, whether that be for sale profit or distribution that's accommodation provided individually, they're there physically or in that proximity, they can be charged today.
Right.
If they're not physically present, so you buy the drugs and go down the street, or the person brings the drugs to you and they leave, they cannot be prosecuted today.
Well, they could be prosecuted for
distribution. They could be prosecuted for distribution today.
But not for
So
felony
this is
murder.
an additional charge. The charge is because the individual passed.
So it becomes felony murder under your bill because they weren't there when all this happened.
Mr. Chairman, it was before 2012 in the Woodard case, people thought it was felony murder. After the Woodard case, the proximity element had to be added in. This takes away that proximity element.
Yeah. Okay, this bill was defeated last year in this committee, right?
Mr. Chairman, I didn't pull that up. All I know is it was vetoed.
A similar House bill.
It was vetoed in 2019. I did not introduce it last year.
I think there was another bill, 29 last year, McGuire, 2022.
Yeah, Mr. Chair, yes. There was a bill before this committee, House Bill 108, which was heard by this committee and was passed by indefinitely 9-6.
Okay.
Oh, it was a House bill.
It was a House bill that came over. Okay, now you have some people who'd like to speak, is that right?
Yes, Mr.
Chair. Yeah, okay, thank you.
If any Zoom participants would like to speak on this bill, please raise your hand electronically now.
We have some people in front of us right now. We'll take these first and the people on Zoom later. Okay, you go ahead.
Thank you. Good morning, ladies and gentlemen.
Try to keep it to 2 or 3 minutes. If you don't
Yes,
mind.
sir. I think I can get it in
sure.
just over one. My name's Joseph Burnett. I'm here with my wife, Paula. We're from Forest, Virginia. Just want to thank you, this committee, for hearing our testimony regarding in support of Senate Bill 881. Just as a matter of testimony, on April 2, 2018, our lives were forever changed. We received a call informing us of the death of our precious son, Jeremy. Jeremy died as a result of the consumption of an opioid that was laced with fentanyl, according to the ME. I don't know who he received it from, but I do know that we've lived 4 years grieving for the senseless loss of our son. When I read this bill, I felt that this truly is a measure that would discourage the distribution of these deadly drugs. I believe the furtherance of this bill would not only save lives, but also the pain and suffering that families endure in the wake of a senseless loss of life. And that grief doesn't go away. It becomes easier to cope with. It doesn't go away. So, thanks for hearing that testimony.
Sorry for your loss.
Thank you, sir.
Okay, thank you very much. Senator Carrico.
Good
welcome.
morning, Mr. Chairman. I'm just here on behalf of the Virginia State Police Association to speak in favor of this bill. A lot of our agents are exposed to a lot of these drugs, and to try to capture these individuals before they beat feet and run to Kentucky or Ohio, where a lot of this is going on, this law will benefit us greatly. Thank you.
Okay, thank you. All right, next.
Mr. Chairman, members of this distinguished body, my name is Dylan Bishop. I'm here on behalf of the Virginia Law Enforcement Sheriffs. These are the sheriffs and sheriff's deputies that have the primary law enforcement responsibility in their communities, of which there are 86 in the Commonwealth. We support this legislation because it does target the folks that are the really bad actors here, the major distributors, which after the Woodard decision have been narrowly interpreted to fall outside the purview of the felony homicide statute. So we encourage the passage of this bill. Thank you.
Okay, thank you. Next, thank you. Welcome.
Mr. Chairman, my name is Robert Tracy, Section Chief for Major Crimes and Emerging Threats at the Attorney General's Office. Attorney General strongly supports this bill. It's a simple bill, notwithstanding some of the discussion that took place today. If someone sells a drug to an individual and that individual overdoses and that drug was a proximate cause of that person's death, the person who sold the drug could be charged with distribution and felony homicide. Current penalties are insufficient. Drug overdoses are escalating out of control. This week, the CDC indicated that drug overdoses among 14-year-olds and younger have tripled in the last 2 years. It is time to have Virginia law reflect the significance of what's happening in our communities throughout the Commonwealth. My question to the committee is, how many more deaths need to take place before this committee responds? Thank you.
Next.
Good morning, Mr. Chairman and members of the committee. My name is Victor McKenzie, and I am the Executive Director of the Substance Abuse and Addiction Recovery Alliance, or SARA, Virginia. We are a statewide organization that advocates, educates, and supports individuals in recovery. Today, I stand with them in opposition to this bill. Criminalizing those who may have unknowingly distributed a controlled substance is a slippery slope and could lead to unjust convictions. This bill also fails to address the root cause of drug addiction and instead punishes individuals without addressing the underlying issues. I've heard a lot of scenarios painted about individuals who utilize and those in recovery, and today I brought two with me to share their stories. Thank you, Mr. Chair.
Thank you. All right, next.
Distinguished committee board members, I want to begin by thanking you for the work you do and for your committee to the health and safety of the
What was
citizens.
your name, by the way?
My name is Frank Bellinger. I'm the founder and chief executive officer of Starfish Recovery and Wellness. I'm also a constituent of the Patron. And also thank you for the opportunity to speak. I'm also a person in sustained long-term recovery from substance use disorder. My company is actually registered in Mechanicsville, and I'm here today to provide my input on proposed legislation regarding fentanyl. And I understand that the intent is to protect those who suffer from substance use disorder and to deter others from exploiting those suffering from this disorder. But I believe this legislation will have the opposite effect. Unfortunately, fentanyl is everywhere, even in substances other than opiates. If this law goes into effect, it will discourage people present during an overdose from calling for help, which could result in unnecessary, even more deaths. And so we heard the Attorney General who's supporting recovery. And so this actually is counterintuitive to what we're trying to do. Distributors, drug dealers, absolutely, but this bill is bad public policy. It's bad public safety. It doesn't address that. You're going to incarcerate more addicts and accrue more tax. And I'm a lifelong Republican. And this is not the Republican Party. This is big government, massive spending, and the tax liability that's going to be accrued on we the people. It's $40,000 a year to incarcerate. You're going to mandate 5-year sentence on a sick and suffering addict who was present at an overdose because he was sharing his drugs. That's what we do. I'm coming up on 5 years, God willing. You know, and I'm sitting here telling you this is bad public policy. This bill is not how you want to go. And with all due respect, like I said, I'm a lifelong Republican. I'm a conservative, socially liberal, fiscally conservative. But this is bad public policy, and you're going to have 25,000 addicts being locked up every single year because they're addicts. Treat the disease. Don't criminalize it. Don't continue to build the prison industrial complex. Thank you for letting me speak.
Okay, thank you. Next.
My name is Chauncey Beeston. I am a person in long-term recovery, and I am the executive director of the harm reduction nonprofit Where You're At Foundation. I'm here today in opposition to this bill. Throughout the years, I've watched my friends die of preventable fatal overdoses because the people that were with them were afraid to call 911 for fear of prosecution. I myself have been arrested for seeking emergency services for a boyfriend who had overdosed. Thanks to our new Good Samaritan laws, we are seeing more people calling 911 in an overdose situation. This is more imperative than ever as we are seeing the rise of nitazene and xylazine and naloxone. It's not going to be enough. We need people to call 911. They need oxygen. The data on drug-induced homicide laws like this one show that they do not catch drug kingpins. They imprison the friends and family members of the deceased and low-level street dealers who are often users themselves. I heard you discuss about how, accommodations. I'm sorry, when I used drugs, we did not accommodate our friends with drugs. We were selling them to them because we were struggling. We needed the money. We are the ones who are victimized because of these laws. They do not cut back on drug sales, distribution, or drug use, and they increase the risk of fatal overdose from 7 to 20%. There are many public health strategies we can employ to fight the overdose crisis. Punitive measures like this one kill more people. Please do not pass this bill. Our lives depend on it.
Okay, thank you. Next. Your name?
Hi, my name is Juanita Belton. I'm a member of Sisters in Prison Reform.
Go ahead, speak louder.
And I'm in opposition of the bill. I'm also a medical provider, and criminalizing people for having substance abuses is wrong. If anything, instead of thinking about incarcerating people, we need to be thinking about giving them the resources that they need so that they're not using drugs and so that they're not selling drugs. And that's why I oppose this bill.
Okay, thank you. Next.
Thank you, Mr. Chair, members of the committee. Sean Winetta speaking on behalf of the ACLU of Virginia. We shouldn't be further.
Which association?
The ACLU of Virginia,
Yeah, right.
Senator Edwards. We shouldn't be further criminalizing people with substance use disorders. And I'd like to note the chilling effect that this is going to have on our Good Samaritan laws, which has been mentioned a little bit before. Of course, Senator Peterson, Senator Boysko sort of started that process here through this committee, and Senator McDougal, I know, spoke in favor of these as they've come through in recent years. I'm also, prior to my work at the ACLU, and I still on a volunteer basis, teach opioid overdose reversal for the Department of Health. And one of the things that we teach people in these classes in the Revive program is that if you are in a situation where somebody is overdosing or somebody is in an opioid overdose crisis, to call 911 and to get help on the way. Far too often what happens is people would run away or we've even heard stories of people putting people in an overdose in a closet and leaving them there. This bill would have a chilling effect on those laws of encouraging people to call and get help on the way, the critical help that is needed, like naloxone, like CPR. This will lead to further deaths if we have that effect, because we won't be able to tell people to call anymore, and people will stop calling. So we ask that you oppose the bill. Thank you for your time.
Okay, thank you. Next. Your name?
Hi, my name is Chelsea Higgs-Wise, and I'm the Executive Director of Marijuana Justice. I'm here to oppose this bill which is continue to criminalize folks that need help with addiction. And when working with marijuana and distribution and looking at those laws, it'll continue to just pack our jails rather than giving folks the help that they need. Bottom line, that this will not save lives. This will just continue to crowd our court systems with nuance about what killed who and where that came from, when the truth is that we still have a lot of information to learn. So thank you so much, and please oppose this bill.
Okay, thank you. Next. Your name?
Hi, I'm Elizabeth Hobbs with the Virginia Sheriff's Association, representing the interests of all the sheriffs in Virginia, and we support this bill.
Okay. Yeah,
Mr. Chairman.
Mr. Chairman.
I believe. Go ahead.
But, Mr. Chairman, I want to make sure the committee is clear. Today, this law doesn't pass. If you're using drugs with somebody and you give up to them, you're going to be charged, and they die, you're going to be charged with a felony. Felony homicide. Today. No change. If you give it today, you're going to be charged. But the drug dealer cannot be charged. So all the information we're hearing about, I was the original proponent of the legislation for the Good Samaritan, because a child I knew growing up, father was a prosecutor, she was given drugs, and her dealer put her in the closet, and she died in Chesterfield. And that law now is for you to be able to call and not be charged with possession. But if you give the drugs and the person dies today, you can be charged with felony homicide today. So this does not change that. So everybody that's worried about that, it is the law today. What cannot happen today is the dealer, the person that originally cut the drugs with fentanyl, they get off. You can't charge them for felony homicide. So that's the individuals that this bill will allow to be convicted and go to prison. Because today, the individual that was using the drugs with you, that brought them in, that's sitting beside you, they can go to prison today. But the person that originally cut it with the fentanyl, they cannot. Okay. So if you vote against this bill, you're saying that the person dealing the drugs, you're okay with them getting away with not being convicted and going to penitentiary. But the person that's giving it to you, sitting beside you, they still can go to the penitentiary.
Senator? They can still be charged with possession, right? Yes. Okay.
And felony homicide.
Yes. Senator Morrissey.
You keep saying that the person that distributed what we refer to as a really bad apple gets away. Would you not agree that that person can still, to this day, be prosecuted for distribution of drugs? Yes or no?
Mr. Chairman, they can be prosecuted for distribution, but not the murder.
Right.
So the person dies, and there's no culpability for the death. But the person that's sitting right beside them, if they say, here, use some of my drugs, that person is going to be charged with felony homicide, and they can be convicted today.
Okay. Senator Peake, I believe.
Mr. Chairman, we have several speakers on Zoom.
There's several people who still like to speak. Is that your final statement?
Well,
okay.
It's now my final statement, but they can certainly want to hear from them.
Yeah, Senator Peake has a question, though, I guess.
Well, I thought we were speaking about the bill, so we're just.
Well, no, we still have people online.
I will then, Mr. Chairman. So this only applies when there's a death, correct?
Right.
Mr. Chairman,
Just
yes.
a death.
Somebody has to die as the proximate cause of using a drug that was distributed.
Okay, online. So we have several people online who'd like to speak.
Yes. Jenny Atwood, you may unmute and speak now. And Harry C., you will be going next.
How many people are there online?
There are 7.
Okay, 2 minutes apiece.
Hi, can you all hear me?
Yes, we can hear you. Go ahead, please.
Okay. Good morning, Chairman and honorable members of the committee. My name is Jenny Atwood-Lovett, and I'm the Executive Director of the Chris Atwood Foundation. I'm also a grieving sister who lost her brother to an opioid overdose, and I can understand and empathize all too well with the family who shared about losing their son. How much I was tempted to want to seek vengeance against the person who dealt or shared the drugs with my brother, but continuing to perpetuate harsher and harsher consequences in this failed war on drugs is not the answer. If we want to create meaningful change and actually save lives like my brother and the son for whom this bill was launched, we need to spend our time and our money investing in not punitive responses, but therapeutic responses. And I am concerned greatly, as has been mentioned many times, about the chilling effect that this will have on the great work that Virginia has done recently, thanks to Senator Boysko here, on improving our safe reporting of overdoses law. Because at the end of the day, this is all about human behavior. We seek punishments like this to change human behavior for the better, right? And this legislation simply is not going to deter any of the damaging behavior in this particular population with this particular issue because of the way addiction works in the brain. One of the core components of the definition of addiction is continued use despite negative consequences. So, as harsh of a consequence as this is, it's not going to stop use and sharing and small deals. And as was stated earlier by an individual in recovery, there's a very, very vague line between somebody who's using and somebody who's dealing. Almost everybody with a substance use disorder has engaged in dealing behavior to support their own use. And this is not going to work to deter that, but it will deter them from calling for help in an overdose.
Thank you. Thank you very much. We appreciate it. Next person online. Who's next?
Harry C., you may unmute and speak now.
Good morning. Can you hear me?
Yes, go ahead.
Good morning. My name is Harry Chazen. I'm a police officer in Charleston, South Carolina. I would be there today, but I'm currently deployed out of the United States to Cuba with the United States Coast Guard. I'm here to speak about my sister. She was an EMT helping the community. She got hurt on the job and was prescribed opiates. She became addicted. And when the prescription ran out, she turned to other methods of feeding that, and she overdosed. She was sold fentanyl, she shot up, and she overdosed. And I just want people to realize that this can happen to anybody. She was helping the community. We came from a military family. We came from a strong background, and we did everything we could, and she still got hooked, and she was sold something that killed her. And another thing I want to say is I spoke on this behalf of 2018, and since then I've made it my job to, whenever I encounter somebody who's charged with distribution, ask if they would have thought twice about selling if they knew there was harsher penalties. And it was a resounding yes. This was all employed with Fairfax County as a law enforcement officer, and all of these people charged with distribution, they all said, yeah, I'd think twice. I never really thought about that. So I do want you to know that dealers would think twice if you guys pass this bill. They don't want to go to jail for a lifetime. 12 months for distribution is nothing to a lot of people, and I just would like that to be put out there. Thank you for your time, and thank you for listening.
Yeah, thank you. Next.
Tom J., you may unmute, and Sean M., you will be going next.
Mr. Chairman, members of the committee, my name is Tom Jackson. I'm a person in long-term recovery since May 13th, 1991. I'm also here on behalf of the Virginia Recovery Advocacy Project, and also a registered peer recovery specialist in Virginia, training the next generation of peer specialists. As Jenny said, one of the primary definitions of addiction is continued use despite catastrophic consequences. And when we are in the middle of seeking and using drugs, whether something is illegal, what the penalties are, what the consequences are, we simply flat out don't think about. And this is a public health issue. We've spent over $1 trillion over the past 51 or 52 years on the drug war, and it has been a colossal failure. If we had spent a tenth of that on recovery services, we wouldn't have this problem. We can't reduce the supply. We need to reduce the demand, and laws like this just simply do not affect that.
Okay, thank you.
Thank you.
Thank you very much. Next. Next person.
Sean M., you may speak.
Hello, Senator Sean McGowan, members of the committee. Virginia Police Benevolent Association stands in support of this bill. Thank you.
Okay, thank you very much. Next.
Brad H., you may speak, and Nathan M., you will be next.
Hi, Brad Haywood. I'm a board member with Justice Forward Virginia and Chief Public Defender for Arlington County and the City of Falls Church. There's been a lot of talk today about how current penalties are insufficient. That's been said by a number of people. This bill aims to create a second-degree murder felony, which would be punishable by 5 to 40 years in prison. For those of you who don't know, possession with the intent to distribute narcotics is punishable by 5 to 40 years in prison. We are not without adequate ability to punish these offenses. And I can tell you from personal experience, in Arlington right now, there's a possession with intent to distribute case that they're claiming resulted in someone's death, and it's basically being punished as a murder case. And they have plenty of prison time with which to work. In fact, 40 years is well above even the high end of the guidelines for first-degree murder. So this notion that we don't have the ability to punish these offenses sufficiently, I think is ridiculous. The only thing that happens when you turn it into a murder case is you put some of the murder detectives on it, and you start wasting resources. Murder cases result in an incredible amount of litigation, and this just doesn't make sense. So thank you.
Okay, thank you very much. Next.
Good morning, Mr. Chairman, members of the committee. My name is Nathan Mitchell, and I am a person in sustained recovery from a substance use disorder. I'm testifying today representing myself in opposition to SB 881 and ask that the committee vote against this unnecessary and potentially harmful legislation. I appreciate the intent behind this bill. As a person in recovery who works with people seeking and maintaining recovery, I have seen firsthand the devastation of the addiction epidemic, having lost loved ones and friends, many friends along the way. No one will argue that substance use-related deaths are horrible and preventable. Instead of enacting more barriers to recovery, however, and burdening the courts with lengthy trials, the Commonwealth should continue to support pathways to recovery. I'll cut a few things that have already been said before, but I do want to leave you with this thought. A May 25th, 2018 article in the New York Times found that using laws like this that are devised to go after drug dealers have in fact been charging friends, partners, and siblings, even one person who was charged with murdering his mother as a result of giving her heroin after her pain medication had been cut off. These are the types of things, and you can see there's a USA Today article back in August of 2022, and a Wall Street Journal article in December of 2017 that discuss the same issues that everybody here has already been talking about in opposition. So we must continue to invest in healthcare solutions that build stronger families, create safer communities, and produce healthier citizens. Thank you.
Thank you very much. Next.
We have 2 speakers left, Sheriff Richard and then Raheel.
Good morning, Mr. Chairman, members of the committee. I am Richard Vaughn, Sheriff of Grayson County. I'm also the president of the Virginia Law Enforcement Sheriffs. We have about 1,400 members across the state. On November 15, 2008, we investigated a fatal overdose of a 17-year-old kid. The victim was dead upon our arrival. The kid had been to 2 different parties that night. At the first party, he ingested some Xanax and some alcohol. Later that night, he went to another party where an adult male sold him some Subutex. The adult male knew that he was under the influence at the time, but he still sold it to him. Subutex is a highly potent pain medication. When mixed with other substances, it can cause respiratory failure or death. We were able to charge the adult male drug dealer with felony homicide in this case and help bring some closure to the family and serve justice on the drug dealer and keep him locked up 5 to 6 years to prevent him from selling to other people and causing yet more deaths. Because of the Woodard case in 2014, we can no longer charge with felony homicide if the victim or the drug dealer has left the area. The Virginia Law Enforcement Sheriff supports this bill and asks you to please consider passing this bill. Thank you.
Thank you. Next bill.
Yeah, my name is Raheel. I'm a person in long-term recovery. I oppose this bill because I feel like you know, instead of people calling the police when someone's overdosing, like a lot of people mention, you're deterring them from doing the right thing and saving their lives when it needs to be saved. Thank you, and I oppose this bill.
Okay, thank you. Next person?
That concludes our speakers, Mr. Chairman.
Okay, thank you very much. Does
Mr. Chair.
anybody have any further thing? Senator Morrissey.
Speaking to the bill, this is a very well-intentioned bill, very well. And to Mr. and Mrs. Burnett, there is a special place in hell for an individual who distributes drugs and that results in a death. An even warmer place in that same locale when they purposely lace it with fentanyl. But this bill is flawed, and here's why, respectfully. Right now, this would dramatically expand felony murder in Virginia. Right now, if an individual, two boys, go into a yard and steal some lumber, it's grand larceny. A neighbor comes out and is pointing the gun at them and trying to dissuade them from stealing, accidentally discharges the gun, killing one of the boys. The surviving boy can be charged with felony murder. What this bill does is it allows that, as you correctly say, the person who distributed the drugs to be charged with felony murder. And Ryan, you said, well, he can't be charged with murder. He can be charged with distribution. He can get 40 years for distribution, and if he's charged here, he can also get 40 years. Okay, so he could get that 40 years, but here is the problem with the bill. This bill, as many of the people said, will necessarily, I believe, cause an increase in deaths in Virginia. I cannot tell you from talking to paramedics the number of people's lives that have been saved because they called in and said somebody is ODing. Let's not conflate distribution or dealing or sharing. They save that person's life, and that won't happen now. It's less likely to happen to call in when that occurs. So for those reasons, because it dramatically expands felony murder in Virginia, because you can already prosecute the individual, and because it will cost lives, because people will be reticent to call in. That's the reason that I'm going to oppose the bill. And with all deference to Mr. and Mrs. Joseph Burnett, I think everybody feels your pain for your loss.
Okay, Senator,
Mr. Chairman.
Delegate Senator Peake wanted to say something. And then Senator Borsko.
Thank you, Mr. Chairman. Speaking to the bill, it's a horrible situation, and I'm so sorry for what y'all have had to go through. But so many people in the recovery aspect of this talk about this won't deter drug use and it won't deter this or that. But some of our laws are made to punish people for their voluntary and intentional actions. And when you voluntarily and intentionally put in the stream of the populace drugs laced with fentanyl, which you know will kill people, you deserve to be punished. And you deserve to be punished for what you actually did. You murdered that individual. I support this bill.
Okay, Senator Borsko.
Thank you, Mr. Chairman. I'm a member of the Substance Abuse Services Council, and I just wanted, for the record, for the committee to know that everyone on that committee unanimously opposes further criminalization of substance abuse-related incidents because, as many of our folks testifying have stated, that these should be health-related issues. We should not be criminalizing addiction.
Okay, anybody else would like to say anything? The bill, if it's reported,
Mr. Chairman, I think Senator Norman would like to say something.
$255,000 fiscal impact.
Mr. Chairman, I would like a 30-second wrap-up.
Okay, go ahead.
Mr. Chairman, I want to make sure we're all talking about the same thing. Right now, you look in the last number of years. 2020, 1,627 people died from drug-related overdoses. That was 2019. 2020, 2,309. 2021, 2,667. And even though the numbers aren't in totally for 2022, we know of already 2,608 people died from drug-related overdoses. Today, if a person is using drugs with their friend or buddy and they proceed to overdose and they call in and the person lives, they will not be charged with possession under the Good Samaritan law. I initially patroned that bill and it passed. Senator Boysko put through some additions to that. We all think that's a good idea. But today, if that person doesn't call in and the person dies, or they call in and the person dies, if the person dies, they can still be charged with a felony today because they're in the room. The person that cannot be charged, the one individual that cannot be charged today is the person that put the fentanyl in originally and sold the drugs. This would allow that person to be charged. So if you don't pass it, the only individual out there that will not be convicted without passage of this is the dealer that put the fentanyl in the drugs. So to be clear, that is what we're doing. Because today, the person in the room with you, they can be charged, and they are being charged.
Senator Peterson wants to say something.
Thank you, Mr. Chair. I'm ready for a motion.
We've already got one.
We already got one. Let me just speak briefly to the bill. The Good Samaritan law, and I hate to do this, it was my bill. It was in 2015, it was Senate Bill 892. It was Betsy Carr had the bill in the House. That was the original Good Samaritan bill. And it's been improved upon. And Senator Boysko and Senator McDougal, people have done good work. And I think we've all been in the same place, which is we want people to get help. We want people to get help. We want to save lives. And we're going to sort of work out the legal justice ramifications later. But the very first priority is saving lives. I think the point that Senator Morrissey made was salient, which is we already have a felony for drug distribution. And it's a pretty darn serious felony. The problem with felony homicide is there are all sorts of examples where felonious conduct can lead to a death. Someone once gave the example in law school about somebody who walked into a voting booth to vote illegally and knocked it over and hit somebody and killed them. That could be a felony homicide. The point is there needs to be proximity between the conduct and the death for this to have any sort of legitimacy. And I feel like the Supreme Court made a pretty good distinction in Woolard saying ordinary drug dealing in and of itself is not a felony homicide unless they're up close and personal and see the victim die and they're there. That there has to be some type of temporal restrictions to the charge. To me, this would wildly open the door for felony homicide. So basically any drug distribution could be effectively a felony homicide. I don't think that's going to solve the drug crisis. And I agree with you, Senator, there is a drug crisis. It's gotten worse. I agree. But I don't think this is the solution, so I would support a motion to pass the bill by.
Second. All right. The substitute motion is to pass the bill by indefinitely. The senator moves the previous question. The previous question would go back to the original bill motion to support. The motion is to order the previous question.
Right.
All in favor, vote aye.
Ayes 7, noes 8.
The previous question is not ordered. So now we go back to the motion to pass the bill by indefinitely. All in favor of the motion to pass it by indefinitely, vote aye. All opposed, no.
Ayes 8, noes 7.
The motion carries. The bill is passed by indefinitely. Thank you,
Thank you,
Senator. Okay, we move on to the next bill. Which is,
Yeah, I'm ready.
Serval's got a bill that he and
Siobhan Donovan. Okay. Is Senator Donovan here? No. Y'all worked it out. Okay.
Mr. Chairman, I talked to Senator Donovan. She said she'd be fine if her bill was rolled into mine and she was made chief co-patron of my bill.
Okay. The motion is to roll Senator Donovan's bill, which is 837, into Senator Serval's bill, which is
835.
835. Is there a second to that motion? All in favor of the motion to roll Senator Donovan's bill, 837 into Senator Sherville's bill, vote aye. Okay, the motion carries.
Ayes 15, no zero.
Okay, now the motion is to adopt Senator Sherville's bill.
Well, I got to explain it.
Yeah, go ahead and explain it. Good idea. 837.
Thank you, Mr. Chairman. Says Senate Bill 835 has to do with the sale, renting, or loaning of certain books to juveniles. There's a section of the code, Chapter 8, Article 6, which I'd never read before. This came to my attention, but it basically says how you can give, for the sake of better argument, a dirty book, or what you can't give a dirty book to a child. You can't have it on display. So this is like why, if you go into a store, like if the Playboy magazines are like covered up so you can't see them. It also makes it a crime for somebody to sell somebody like a book like that to a child, right? So Section 18.2390 of the code, for purposes of that statute, defines what sexual conduct is, and it has a really outdated concept in there, which is that it defines sexual conduct as including homosexuality all by itself. So in other words, if a book just simply says that a child has two fathers or two mothers, and that's all it says, no sexual activity or anything, just says that, if it depicts a homosexual relationship, then it constitutes sexual conduct for purposes of this criminal statute. This came to my attention, and also the member of the House who brought it to my attention, because I think Governor Youngkin referenced this definition in connection with his obscene book standards for schools. And it's really an outdated concept and needs to come out of the code. Because we don't say any book that depicts heterosexuality as sexual conduct. We shouldn't say it for homosexuality, and that's basically what the concept of the bill is. Senator Donovan's bill proposed to strike homosexuality out and replace it with sodomy. I convinced her that the remaining language in the sexual conduct statute covers that, so it's not really necessary, and she now agrees with that. And so I'm not aware of anybody. I'm not sure if anybody opposed the bill. If they are, nobody said anything to me about it.
Okay. Any questions, or anybody would like to speak one way or the other? Is there a motion that we report the bill? All in favor of the motion to report 835, vote aye. All opposed, no.
Was there a sub? Oh, it's reported as a sub.
Yeah, report. It doesn't have to go to finance.
Finance?
I'm sorry, yeah, report the substitute, which is the 837 rolled into 835. So the motion is to report the substitute for 835. Vote aye.
Senator McDougal for Obenshire. Ayes 9, noes 4.
9-4. Okay, the motion carries. Okay, the next bill, Senator Peterson? No. Senator Morsi, okay. Senator Morsi has consecutive terms of imprisonment.
Yeah,
Senate
true.
Bill 888
That's possible.
eliminates the required imposition of mandatory consecutive sentences of imprisonment. Senator Morsi?
Good morning, Mr. Chair, Mr. Chairman, and fellow members. This bill does not eliminate mandatory minimum sentences. It just eliminates the requirement that mandatory minimum sentences be consecutive. It allows a judge to impose a mandatory minimum sentence, and there are 200 of those laws on the books, but allows the judge to run them concurrently. The Commonwealth expects our judges to review the unique circumstances in each case, use their discretion. This bill allows them to do that. The exercise of this judicial discretion is limited when the law requires and mandates that that mandatory minimum be stacked. So many judges have said, I don't want to do this, but they do it. Or the person is prosecuted and is given seven charges, and the prosecutor will say, if you don't accept this, you're facing automatically 82 years, say 5 years times X number of charges. It allows the judge discretion to impose a fair sentence. Now,
Senator Dees has a question.
Senator Morrissey, I would ask, there's nothing in your bill that would prevent a judge, if he or she feels it appropriate, to providing for consecutive sentence.
Thank you for that. And the answer is, to your question is yes. The judge could still do that. Lawmakers here in front of me, some of us disagree on whether we should have mandatory minimum sentences. That's fine. But across the board, people do not disagree that the crime or the punishment should fit the crime and that mandatory minimum sentences should be stacked. So that's what that does. SB 888 would allow judges to decide whether a person convicted of an offense tied to a mandatory minimum should serve those sentences concurrently, or consecutively. That's all it does.
Okay, thank you. We often have sentencing guidelines, right?
Pardon me?
We always have sentencing guidelines.
The judge would consider that sentencing guideline.
Okay. All right, thank you. Any questions? Okay. Okay, some people behind you would like to say something.
Participants on Zoom who would like to speak on this bill, please raise your hand electronically now.
No more than 2 minutes, okay?
Rob Pogenclass, I'm Executive Director of Justice Forward Virginia. We support the legislation. I think the senators explained the bill very well. This does not tie the hands of judges. In fact, this unties the hand of judges in their ability to sentence accordingly, whether they feel it effectively gives power back to judges as to what the ultimate sentence will be. And so we support the legislation.
Thank you. Next.
Thank you, Mr. Chair, members of the committee. Sean Winetta, speaking on behalf of the ACLU of Virginia. We support the legislation. We believe it puts discretion back into the hands of the court where it belongs. Thank you.
Okay, thank you. All right, next.
Good morning, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We are opposed to the bill because those 200 laws that Senator Morrissey referenced were not taken up in one fell swoop. Each time they were brought before the body, and the merits of whether or not the legislature should put guardrails on what a judge should do with that minimum sentence were taken up one at a time. There are a number of these 200 laws that the Commonwealth the Association might actually support taking a look at it, but let's take a look at them one at a time, as opposed to taking an axe to the entire idea.
Mr.
Senator
Chair.
Peterson.
Mr. Chairman, we have 2 speakers on Zoom.
I have a question,
Senator Peterson.
actually a comment. I've been here 22 years, and I was probably in the body for most of these mandatory minimums. And I think if you would have asked a membership on the floor at the time they voted whether or not those sentences would run consecutively or concurrently, if there was multiple convictions, I think maybe 5% would have known the answer to that question.
Mr. Chairman, I don't know. I don't have an answer to that. I haven't been involved for the 22 years.
The judge can give consecutive sentences if they want to.
They can. And Mr. Chairman, again, the General Assembly has the power to say to a judge, you have a range of punishment, but we are going to restrict it because we feel a certain way about this, whether it be capping the maximum or limiting the minimum. But it's done on a statute by statute basis as opposed to taking an axe to the entire.
And we have sentencing guidelines too.
We do have sentencing guidelines here, but they don't take into account the mandatory minimums other than checking a box saying that there are mandatory minimums. The guidelines speak for themselves. And as we've just discussed, sometimes we lean into the guidelines. For example, I think we're trying to lean into it now, but when it comes to distribution of narcotics with sentencing guidelines at 1 year, we're willing to ignore them then. So the kind of when we ignore guidelines and when we trust them is not always consistent.
Okay. Anybody else? Anybody else want to speak?
We have 2 speakers on Zoom.
Somebody wants to speak on Zoom, I believe.
Yes, we have 2 speakers. Barbara, you may go first, and Samuel, you're going to go next.
Okay, keep it to less than 2 minutes, please.
Barbara, you may unmute and speak.
Yes, Richard Walker, founder, CEO, Bridging the Gap in Virginia, and we support this piece of legislation, knowing that you have the sentencing guidelines to go by, and in most cases they are they're surrounding the same type of offense, So to run that concurrent, it would be ideal and left in the hands of the judicial system. Thank you.
Okay, thank you. Next.
Samuel, you may unmute and speak.
Good morning, Chair Edwards, Co-Chair Deeds, and members of the committee. Sammy Perez here, speaking on behalf of Prison Fellowship in favor of Senate Bill 888. I have been proud to call Virginia my home for my entire life. Was born and raised in Fairfax County, but fortunately for me, life began to turn at a very early age. At the age of 2, I was removed from my mother's care by the Department of Social Services. Unfortunately, my father had left us well before then. At the age of 11, I became a ward of the state. This began a downward trend. At the age of 15, I entered into the Department of Juvenile Justice. And unfortunately, at the age of 19, entered the Department of Corrections. I'm not proud of the decisions that I made that led to my terms of incarceration and have taken my second chance seriously and really just not taking it for granted. Senate Bill 888 puts the important decision of making these decisions back into the hands of district judges who are best equipped to hand down a proportional sentence guided by their knowledge of law and the circumstances of each case. Okay. I stand before you today as someone who has benefited from the ability of courts to exercise careful judgment. In 2005, I was sentenced to 2 consecutive 5-year mandatory minimum terms or sentences for firearms related offenses. The judge ultimately decided that an additional 10-year sentence should be imposed concurrently rather than consecutively. At sentencing, the judge made a statement that sticks with me to this day, and I quote, "I'm giving you too much time, but I have no other options." Because of this judge's discretion, my overall term of incarceration was reduced by 10 years, allowing me to return to my community as a committed Christian, father, citizen, and leader.
Okay.
I sit in front of you today as a model returning citizen, someone who became a first-generation college graduate, youth basketball coach, mentor for at-risk youth, and father of 4 beautiful children.
Okay. Thank you very much.
Please vote for Senate Bill 888. Thank you.
Thank you. Appreciate it.
Mr. Chairman, we have one more speaker
One
on
more
Zoom.
speaker. Okay.
Lily, you may unmute and speak now.
Good morning. My name is Lily Branch Kennedy, and I'm with the nonprofit organization Prisoners and Family Resource Information Help for the Disadvantaged and Disenfranchised, RIHD. We support this bill. Thank you.
Okay, thank you. Anybody else want to speak?
No more speakers on Zoom.
Okay.
Quick wrap up, Mr. Chair.
Senator Morrissey.
Quick wrap up, 45 seconds. You all may remember the floor speech that I gave where I talked about that juvenile who 2 adults picked him up. They went to a beach summer party. 7 juveniles were robbed. Seven people were robbed. There was a gun present. One of the adults held the gun. The 2 adults pled and got 10 years and 12 years respectively. The juvenile said, "I'm not going to plead. I was there, but my involvement was de minimis." He went to trial. He was convicted of the 7 robberies and the 7 use of firearms. The judge was required to give him 33 years, 5 years for each use of a firearm, for 3 years for the first one and 5 years for the second one, 33 years. The judge said for the robbery, could have given him 7 lives, but he gave him nothing. He said, "I don't want to do this. I have to give you 33 years. I gave that floor speech. The governor called up afterward and said, "Work with me on commuting his sentence." This is what this bill prevents. It prevents and allows the judge to use his discretion and not stack consecutive sentences. I'd ask that all my fellow members, pass this bill.
Okay. Is there a motion? It is moved. Is there a second? Moved and second to report the bill. Any discussion? All in favor of the motion to report the bill, vote aye. All opposed, no.
Ayes 9, no 6.
9 to 6, the bill passes.
Mr. Chair, I'll move on to, thank you. I'll move on to SB 916. 916 creates a Henrico County Public Defender's Office. Currently, there are 27 public defender offices throughout the Commonwealth. Whenever in the Commonwealth we've established a PD's office, we have never, decertified is the wrong word, we have never walked it back. Every public defender's office has met with unbridled success. This would create the 28th public defender's office in the state. Henrico is the 6th largest county in Virginia, just behind Chesterfield, and we created a Chesterfield PD office 2 years ago. Here's the benefit of the public defender's office. It prevents highly qualified and experienced litigators, zealous attorneys that just focus on criminal defense. That is their singular charge. They have investigators in the public defender's office. They have investigatory resources. They have appellate services in the PD's office. And they just give painstaking service to those clients. I don't think this is a controversial bill, but I will tell you this. I can go over the training that they have for the various PDs, but I don't think I need to do this. Just know that they are singularly focused, laser-like, on their criminal clients. They have experts in the office. They have training in the PD's office twice a year. Required, additionally, they are qualified to represent indigent defendants with a certification training process.
Chair.
For those reasons, I'd ask it.
Senator Morrissey, you had this bill last year, and I think we passed it and sent it to Finance. And I'm wondering if Henrico County's taking a position on the bill this year.
What is their position on it? The
Yeah.
county itself? I'm sorry, and I don't know.
Okay.
I'm sorry.
It needs to go to Finance. Okay.
Mr. Chair?
Yeah, Senator McClellan.
My understanding is the county itself has not taken a position, and the Commonwealth's Attorney's Office supports it.
Okay. Is there a motion to report and re-refer to Finance? All in favor of the motion, vote aye. All opposed, no. Vote no. Go ahead and vote.
Ayes 14, noes 1.
Thank you, Mr. Chair.
The bill is passed and reported, re-referred to Finance. Now, it's now almost 10 minutes to 11. Shall we put the rest of them off to Wednesday? Some of us are supposed to go to a caucus. Yeah, Senator Stewart, you want to present your bill? All right, we'll do this one last bill. Senator Stewart, Senate Bill 920, Senator Stewart's bill, employment of school protection.
Mr. Chairman, I apologize. I had to go to local government to present a bill. Did you all do anything with SB 920? I would ask that go by for the week because I have a witness
Okay,
who couldn't get here
will
today.
go by for the day, okay?
Thank you, Mr. Chairman.
958, Senator Stewart's bill, writs of actual innocence.
Yes, Mr. Chairman, and this makes a number of changes to the writs of actual innocence statute that we took up, I guess, a couple years ago. As quickly as I can, it provides a limitations for the filing of the petition of 2 years from the date of the actual finalized conviction or the date they discover the unknown or unavailable evidence. It requires the Attorney General to give notice to the Commonwealth's attorney. It establishes an evidentiary standard, which would be by preponderance of the evidence if you plead not guilty, but clear and convincing if you plead guilty or nolo contendere. And it has some other matters in it. I'm not going to profess to say that I am the one to sell this or answer all the questions. It's the Attorney General's bill, and I was happy to carry it. As a result of the changes we made, which I think I voted for, we're seeing a lot of what we would call frivolous petitions. And that is an unfortunate issue with them. And so the Attorney General has worked with me, and we've tried to address a number of those issues and tried to trim it down a little bit, but still give folks the ability to file these writs, which I believe they should have the ability to do. So with
what
that,
about the 2-year limitations? How do you justify 2-year limitation in filing a writ of actual innocence? If you're innocent,
I'm going to stand aside and let the Attorney General's office help me with this, if you don't mind, Mr. Chairman.
Okay, go ahead.
Good morning, Mr. Chair, committee members. My name is Brandon Robleski. I'm a special assistant to Attorney General Miyares. I handle most of the actual innocence litigation for the office. As Senator Stewart mentioned, this bill does take into account some issues we've noticed since the 2020 amendments. And specifically to your question, Mr. Chair, regarding the 2-year statute of limitations, we did a 50-state survey, found that some states have a commensurate non-biological actual innocence statute as we do, and there are approximately 11 other states that have a 1 or 2 year statute of limitations for actual innocence matters. And this recommended 2-year provision would align the Commonwealth with the writ of habeas corpus, which has a 2-year statute of limitations under 801-654.
Yeah, that's a terrible bill too. 2-year statute of limitations for habeas corpus.
Yes.
You ought to have no time for habeas corpus. You ought to have no time for writ of actual innocence. So if somebody didn't really discover the evidence about actual innocence until after 2 years, you're barred from even raising the issue? Is that right?
Okay, hold on.
No, Mr. Chair, that is not the intent of the bill. The intent of the bill would be to allow 2 years from the discovery of the newly discovered evidence.
Yeah. Okay. Yeah. Anybody else have any questions?
Yeah, Mr. Chair, I guess my question would be,
Senator
I think we're getting some heartburn up here on the whole statute of limitations issue. I think the rest of it's probably fine. Would you accept an amendment to strip that out?
Yes.
Then I would make that amendment.
Second.
Okay.
Yeah. Lines 25 through 28.
If any participants on Zoom would like to speak on this bill, please raise your hand
Well, let's
electronically now.
adopt the amendment, please.
Okay, so it's moved and seconded to strip out the bill, the part of the bill about the 2-year statute of limitations. Is that right?
Yep.
Okay, all in favor of the motion to strip that out, say aye.
Aye.
All opposed, no. Motion carries. Okay, anything else about the bill? Anybody have any questions about it?
Mr. Chairman, one suggestion would be on line 83, instead of providing a mandatory shall, the committee might consider a may, so that the Court of Appeals may summarily dismiss petitions upon certain grounds.
Which line? Which line?
Line 83, substitute may for shall.
83.
We consider that.
May, okay. Is there a second to the motion? All in favor of the motion to strike shall and put may on line 83? Vote aye. All opposed, no. Motion carries. Okay. Anything else about the bill?
I do have a question, Mr. Chairman.
Yes.
On line 86, there's reference to abuse of the writ. My question is that otherwise defined within the mechanisms of these provisions?
Yes, sir. The abuse of the writ is intended to allow the Court of Appeals some discretion in disposing of repeat filers who are filing the same petition over and over again. We had the first case, Haas versus Commonwealth, earlier last year, where a subsequent petition was considered by the Court of Appeals, and then now Justice Russell's question to us was, what happens if we have repeat filers who are consistently filing the same evidence over and over again? This would allow the Court of Appeals to dispose of that more summarily.
Well, I think right now you don't have to have an oral argument for prisoner petitions anyway. They could just dispose of it, right?
Yes, that's
They
correct.
can still do it without even oral argument.
That's correct.
Okay, and so what are you trying to do here?
It was specifically designed to
That's another
address
problem.
now Justice Russell's question of what do we do when we have repeat filers who are bringing the same evidence before the Court of Appeals repeatedly?
There is a process, because I've been involved, at least in the federal system, to order people not to do this, but anyway.
I think, Mr. Chairman, I think this just gives the court discretion.
Okay.
If they believe that they're abusing the process, it gives them the discretion to dispose of it.
Since we changed shall may.
Yeah.
We changed- yeah,
Steve,
that's
Benjamin,
fine.
you have any questions?
Elsewhere in the bill, Mr. Chairman, I'll note, or I just want to draw the committee's attention to the amendments on lines 65 and 66. The bill provides that if you have a situation where a witness has recanted, where they say the testimony I gave at this person's trial was false, currently I think that is generally insufficient for a writ to be granted. But currently, if the petitioner could add to that the fact that the DNA eliminated them as a suspect, then that may be a more compelling case. This bill, at those two lines, provides that even in situations where you have a witness's recantation and you have human biological evidence, that by itself will be insufficient to grant the writ. And I'm not certain why that makes a good policy decision.
Yeah. Why do you want to say you cannot use biological evidence, nor can you use recantation as evidence? Why do you want to get rid of that? Because that's powerful evidence that the person may be innocent.
Mr. Chair, the prohibition on the exclusive use of biological evidence is current law that would transfer the matter to the Supreme Court under their original jurisdiction. But the aspect of the recantations, it simply reflects existing Virginia law, Virginia precedent regarding recantations, which states that they're to be viewed by the courts with skepticism. And as time elapses from the date of the offense, the opportunity for fraud increases with recantations. So that is essentially to reflect Virginia precedent that courts are essentially directed to view recantation with suspicion as it is.
Recantation can be very powerful, too.
It can, Your Honor. And there was one case, Montgomery versus Commonwealth in 2013, where a witness was convicted of perjury, and then that was a certified factual finding by the court that the testimony at trial was false. We're not trying to stop that from becoming prohibited. So if there's a separate factual finding by a circuit court judge that, in fact, the witness did perjure themselves, that would be additional corroborating evidence over and beyond just the recantation itself. So that would still survive under this proposed language.
So why do you want to make the changes on line 65 and on? I mean, you ought to delete the changes. Yeah. Steve?
That would be my suggestion.
Yeah, I make a motion that the changes on line 65 and 66 be deleted from the bill. Is there a motion? Okay. Senator Deeds seconds the motion, makes a motion. I second the motion to delete the changes on line 65 through 67. Is there discussion? All in favor of the motion to delete those changes, say aye. Aye. All opposed, no. Motion carries. Okay, those changes are made. Okay, it's been moved to report the bill as amended. Any further discussion? All in favor of the motion to report the bill as amended, vote aye.
Let me add one
Yes,
additional issue for the committee.
There's a motion.
You see it?
There's a motion on the floor, I think.
Maybe. I'm here to help, that's all.
Yeah, go ahead, Steve.
On lines...
You seem to help me more than others.
I'm always here to help you, Senator.
I guess you know I need more help, huh, Steve?
Happy to help. That's my sole rule.
Okay,
At line 61, this bill creates different standards of proof depending upon whether someone has originally pled guilty or not guilty. Not taking a position on that, I'll just point out that it's taking a step backwards from where this committee has come in prior years in dealing with this. The committee in prior years has recognized that many times people will plead guilty to avoid a harsher punishment. In other words, it may be the product of a plea agreement where they really have no alternative, even though they're innocent. And so this would be a step backwards from where the committee has come previously.
I withdraw my second to that previous motion.
Okay, so the motion,
Mr. Chairman, we have speakers on Zoom.
okay.
We strike the new language on lines 61 through 63.
Yeah, right.
If you're innocent, you're innocent.
Yeah. Yeah. Is there a second? Any discussion on that? All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Some people would like to speak on Zoom, is that right?
Yes, Brad, you may unmute and speak, and Laverne, you're going to go next.
Sorry, Mr. Chairman.
Yeah.
In light of the hour, I mean, it seemed to me this bill's looking pretty good. Unless they're opponents, I'm not clear why we'd want to hear from them.
Let's hear from them, see what they say.
Hi, this is Brad Haywood again, Justice Forward, and
No more than an hour, please. No, go ahead. I'm sorry. Yeah, go ahead, speak.
hi, this is Brad Haywood again with Justice Forward. The provision that Mr. Benjamin just mentioned really should not be overlooked. And we're living in an era right now where 95 to 98% of felony convictions are obtained by guilty plea. And the reason that happens is because of something called the trial penalty. And that is when a prosecutor has so much leverage
Mr. Haywood, we
overcharge
took
you.
that out. Do you have anything else?
Okay.
Yes, the other thing I wanted to mention was about the successive petitions rule. That also is really problematic. As somebody who's, before I had my current job, I did post-conviction work. The obstacles to obtaining post-conviction relief are already almost insurmountable for many people. And here's something very common that occurs. A prisoner will file their own petition. It'll be kind of flawed. There'll be something wrong with it. But there's truthfully a great deal of merit to the claims that person is making. If what happens is then that prisoner gets that first petition denied, and then a lawyer picks it up, and a lawyer sees, oh, wow, you've got a really strong case here. I wish you'd talked to me earlier. And that lawyer then files a post-conviction petition under this code section. They would likely be precluded from seeking relief under this code section. It's just a procedural mechanism for reducing the burden on the Attorney General's office, honestly, and keeping people from getting relief that is necessary. If something like that needs to be in the statute for efficiency's sake, there absolutely needs to be some exception. In certain circumstances where those petitions are particularly meritorious. So that's all I wanted to.
Where in the bill does it talk about successive petitions?
It's the second, if there's a second petition filed.
Talking about the abuse of writ.
Mr. Chair, I believe Steve made an amendment on line 83, changing the shall to a may.
That's
Right.
right. So it's just within the court's discretion.
Yeah, it's within the court's discretion.
Okay.
Okay. Okay, anybody else would like to speak on the bill?
Laverne, you may unmute and speak now.
Yeah, somebody else? Who would like to speak?
Hi, good morning. Can you all hear me?
Yeah. Go ahead.
Hi, good morning. My name is Laverne Russian. I am Matthew Russian's mom. Obviously, many of you know Matthew's case, but I wanted to step in to say that the amendment to the 2-year provision is an absolutely phenomenal exception because it has taken Matthew and I and his team this long, almost 2 years, 3 years after conviction, to actually prove his innocence. So the provisions and the amendments that were made towards this bill is absolutely acceptable to the writ. I just want to make sure that I came on board with you all to validate those changes.
Okay.
So thank you all for everything that you've done for us.
Thank you. Okay, anybody else want to speak?
There are no more speakers, Mr. Chairman.
Move that we report the bill as amended.
Been moved and seconded to report the bill as amended. All in favor vote aye, all opposed vote no.
Ayes 14, noes 1.
Okay. The bill passes 14-1.
Senator Peake has one.
If Senator Peake, you have something you want to do?
Is it worked out?
Can it be done quickly?
Do we have the language on 990?
Since a 990
I have it, but I don't
communication
have a
between
written
ministers
copy.
of
If I can read it
religion.
out loud.
He
Okay.
can read it out loud. It doesn't have a written copy.
It's Senate Bill 990.
Senate Bill 990, we have a number of people here. This bill is to,
You have an amendment?
we have an amendment. In
Mr. Chair,
addition-
Mr. Chair, this is going to take time.
Okay. Yeah, I think they've got it.
We'll leave after this.
No, John, no.
It's gonna take too long.
All right.
Is this
can't
going to
get-
take
all
more
right.
than 30 seconds? Go ahead, quickly.
No, it's not going to happen quickly, Jim.
I tell you what, we'll put this off to Wednesday afternoon, okay?
All right.
So we'll have a chance to look at it.
Thank you.
If no further business, this meeting is adjourned until Wednesday.